Yes.
To mention 61 IA, character of order of
Your Lordship, I beg to make item number 61 of your item. Matter Lord.
61 of
61. Item number 61.
today's list.
Yes, sir. Actually, the matter was wrongly listed to the Lordship. For the both convenient of the both the side matter will be listed on the 22/12 Lordship. Actually, my senior is there is some personal difficulty, Lordship. So kindly adjourn the case to the Lord.
Okay, let it reach. We'll correct it.
Otherwise, my lord may fix the matter on reopening, lord.
No, but if there is an order, it has been listed wrongly. We'll have to pass that. We'll have to record it, no?
There is order also.
So you don't have time. You go home. We'll pass this order.
Lord,
No
I'll
issue.
I'll be here, lord.
You go home. We'll pass this order.
There.
Yes. Next case.
I'll be here.
My petition number, filing number 13223, filing date is started and in 12. I think, if possible,
What?
tomorrow.
What? Yes, that is what matter?
criminal
Huh?
petition, criminal petition 480.
482. Is it the bench?
Criminal
This is not. This is a bench 3. Mentioning you go to the senior criminal bench. This is bench 3. Some bail matters are given due to the rush for vacation. That's all.
Okay, sir. I beg to mention item number 23 of court number 5, bail matter. City was called for part of
Yes, Mr. Das.
city is not reputable. 20. City was called for city is not reputable. Matter may be taken.
I the code number 5 is not there.
Wait. If not there, we will pass that order. Wait for something. Earlier rejected or what? Uh-huh.
It was rejected.
Okay, that's
But the completed 3 months notice.
completed.
3 months order. 9 days.
Item number 1. AB.
AB. Notice coming up.
Court
4269. This is an AB. How can he be for 92 days? $438.
has not arrested them, your Lordship.
You want to get arrested or what?
Lordship, since they have
Till today not arrested. That's what are you doing?
Your Honor, here,
After rejection, you have not arrested. Arrest her. That is her grievance. CD. Let us have a CD. Will not reject on the day one. Let us see any new development. What happened to the person? He died or still in hospital generally?
no,
January 11.
January 11th. Yes, yes, the CD. I think 4 files are not there. Amma.
Please, your lordship. The 430 application. Second bail application. Second period with application.
Whose marriage?
Lordship is daughter.
His daughter's marriage.
He's an old person, lordship.
This is second time or third time?
The second time, lordship.
Hmm?
Second time. Letter it was September 9.
1909.
In September 2000. Whether the victim is alive or not? Alive is lordship, otherwise he will recover lordship. He is doing it for lordship. Very infected but not intentional lordship. That's the
But we recorded that considering the statement comma, statements of the witnesses so far collected, including the and medical and injury report. This is not a fit case forensic.
He will recover the
So, is
Which journal
recovered is
India?
a new ground.
which January dia? Huh? We have time, look, 21st January. Marriage is 25th
25
January.
January.
We will produce case diary before that.
Chief Lordship temporary protection.
And if he is arrested by this time, we will facilitate him to attend the
Ah.
marriage.
Marriage will assure. Otherwise, you are arranging for the marriage, isn't it? Letters are printed. CD when.
Mm. 11th
I
of
recall
January.
it.
11
Severe injuries were there. Eyewitness said that how injuries were inflicted, and the medical report corroborated. Not a case of 438. Yes. Anyway, we'll see. Since you have
11th
come
January.
again. Mr. Mannan, you test.
They will have pay after payment they taken yes. I have. by
To
the
do it, we'll have the instruction and we cannot pass any effective
Yes,
order
that is true,
today.
I also know. But they
So
bring up
we'll
what is it?
see how to expedite the matter.
Even
Fate
if,
we
you know,
cannot
there is
decide.
Another issue, but even if your daughter expedite time, maybe they will do it within 2-3 days. Because what has happened, I have already deposited the doc. They have to verify. Again, going to CPI, I don't know, but anyway, whatever, they will have to verify.
Suppose it
come
is
in-
in your favor, then
then
also
what?
another issue.
Then what?
That will
That will be an
issue.
issue.
That will be an issue because otherwise, this is not your fault. If it is held that
Yes.
it is genuine, then whom to blame?
No, your lordship, now the problem actually because of the division bench order has very critical about the single judge because it was a blanket order. That couldn't happen. That was the,
Let us not comment.
that will not come. I have
Mm,
not commented
no.
on that, but I am saying.
Oh, no,
because
no,
of the
let
blanket
us
order,
ask this court.
yes,
We
blanket
understand, we
order,
understand.
These people have come.
Because in the meantime, in the event it is treated to be genuine or it's correct, then how to be compensated?
Because
If it is a question of compensation comes, then whom to be blamed?
in-
On us?
nobody can say anything.
On us?
So we have
This is
to
a
look into
difficult,
a-
critical question.
There is a way,
So therefore expedite it so that we can
something can
do
be done.
something can be done. That is the issue. And where is Mr. Bora? You have your instruction. And RM Das is nowhere to be seen.
I am representing him, your lordship. He is on late.
On last occasion also in some cases he was not here. We have noted those things. This is not fair on the court upon the court. Anyway, so therefore his stand is that we have sent it. So Mr. Bora, you have your instruction if possible by today we are having at 2. Mr. Okay. We are having at 2. His statement was that we have sent it to CID. So what CID is doing? You have give the number and call them, have a telephoning instruction. Okay. Yes, Mr. Das, can we proceed on the bail hearing? Amma,
We can proceed.
Huh?
We can proceed, but this is.
why
the-
these matters are all these matters
Really?
are
child marriage matter, I think. If I,
what is this affidavit in AB? Please enlighten us what is this? Additional affidavit. Can we pass a common order in bail?
That can maybe taken after supplementary will come. Lord.
Who is your senior?
Mr. A.M. Borpia.
All cases are in the suo motu affair.
All cases.
All cases.
Promoter.
All suo moto that, where is the FIR suo moto?
My senior will
Okay.
better explain you, Lordship.
FIR on the FIR.
FIR, non-registered FIR, Lordship.
For the time being. All are M Borvia or what?
AM Borpia.
All. Is there?
Private respondent is also appear.
None appears for the petitioner on call.
44.
Let me come back then. So what is it? If lawyers are ready, we'll come. Yes, next case.
41 case there is there. One or two case there is not. Sorry.
Not received. But case diary was there on 1910. Then APP MSA Begum was allowed to have a Xerox copy. And keep the Xerox copies and return back the case diary.
Or whether it is on interim or if it is interim,
It is interim. It is in
let
interim.
after vacation.
Okay. But I have seen all these orders, the list after 3 months, no date. How are you managing this? You cannot keep the cities until and
Yes,
unless.
yes. Maybe it has been returned. That is why perhaps it is not.
Ah.
Yes.
Comma. But what to do? There is a specific order, retain the photocopy and send back. Because idea was to.
Well, actually, what happened today? In every court, so many bail matters are. Well, my office is unable to trace out the case today.
Okay.
Maybe photocopy is
The
there.
case diary. Call. We cannot say call for also. Because of the last order.
Nobody has appeared.
Okay,
for the
none
petitioner.
appears for the, that is the best way. None appears for the petitioner on call. List this matter on
On 11th January
11th of January 2023. Interim
24.
order
24.
24th interim order passed will continue.
42 case there is there, fortunately. Malad, they are on interim. They are on interim. Malad, he appeared also. They have appeared and their statements are recorded.
Do you require their hospital interrogation?
Not necessary.
Okay.
Because main accused driver has said his name is not named.
Considering the material available, and also the fact that it appeared after interim order appeared, Huh? Have you recorded your statement? Got his statement recorded. Disposed of, huh?
made peaceful loss. Petitioners are in agreement. On last occasion, actually diary was called for. FIR is a
Interior আছে নাকি? Interior আছে? Statement নাই তো।
page 11.
I do not think in this case you require page 11. FIR, look at the FIR, Mr.
My lord.
A scooter was found unattended. No owner. There is a number. His glass is broken. So it was assumed that this number is fake. It may be used for any other purpose. Why this person is before this court?
My lord, 41 notice was issued, and the petitioner number 1 is the owner of this.
Why have you kept that scooter in that condition?
No, my lord, it's not my owner's matter.
Huh?
Somebody else scooter matter. I'm the dealer of this Honda authorized dealer matter. And petitioner number 2 runs and looks after the entire dealership. So we are
No,
asking.
it is pending in the dealership.
No, not dealership. My lord. It was parked in his residential compound map. And FIR was lodged by the Jorhat police.
No, we understand.
Yes.
The scooter was parked in a compound of a flat,
Flat map.
isn't it?
Yes.
You are one of the
I'm
Yes.
the dealer map.
dealer of.
JB Honda Private Limited.
Okay. Now, how you stay in that?
No, my lord. They profit.
My goodness, they have asked to verify where is the chassis number, engine number, to whom it's registered, and you have come for a bail.
They issued me 41 notice, my lord.
41 issued notice because they want to know about the chassis number. This is a fundamental
We have provided.
because that bike belongs to Honda.
Honda.
You are the dealer of that area, so they want to verify whether this has been purchased from you.
My lord, we have provided all the details, my lord, as required by the IO matter.
We'll say cannot be any apprehension. Therefore, we'll dismiss this bail petition.
Because, my lord,
The petitioner
knowledgeable
number 2
section
has
is-
appeared,
Uh,
but petitioner number statement of
who is
petitioner
petitioner number 1?
She is the owner of the
Vaishali
Honda
Murali.
Private Limited, my lord.
Go and give your statement.
Yes, my lord.
Absolutely. Don't come for all these cases.
Of the
Unnecessary wastage of judicial time. Police has not gone to that extent, we believe. What you say, Mr. Das?
Yes.
Absolutely.
of the
Subject to condition that petition number 1 will appear before the IO within a period of 10 days from today.
My lord,
Huh?
I'm extremely sorry, my lord. 41
Mm.
is there. I kept the file aside.
Okay.
My lord,
Okay.
CD is there. That can be disposed of. My lord, they have appealed.
Okay. None appears, no?
None appeared.
None appears. Pursuant to order of this court, the petitioner has cooperated. Full stop. Also peruse the
Their statements are recorded.
material so far collected by the investigating authority. On perusal of the same, this court is of the view that no custodial detention shall be required for the investigation. Accordingly, the interim order made on so and so is made absolute. This will be the order.
Yes, Your Honor.
NDPS.
NDPS.
NDPS anticipatory. Where is the FIR?
There is a Panchama, my lord, page number 30.
Hmm?
Page number, it starts from page 30.
Page 30.
1 6. And the case diary was solved.
Okay, final complaint has been
Final complaint has been filed.
on 28/11/2023.
Is he having any interim?
No. Is that this person, Soriputi.
What is your allegation against you?
There is no allegation against me in this Panchama matter.
Hmm.
But my lord, what happened? The DRI officers, my lord, visited my residence. I was in Karnataka, my lord. When I came back to my house,
What your final complaint says?
Lordship, I couldn't bring.
Huh?
I couldn't bring file, Lordship. My senior is not there. Lordship, I have received this information. That's final
You have it. NDPS will, if nothing is there, he will go there. He should be inside. So was the final complaint.
my lord, before vacation.
Lordship, after vacation.
Then we'll give him interim. Have an instruction. What is your allegation against him? If nothing is there, it's a stringent act. FIR, no, not anything in the FIR against him. Huh?
Against this person, nothing is there.
You want to call your senior?
No, Lordship, I have to call my senior.
Call
I
your?
have to receive instruction from department.
Okay. Hmm. What to do, Mr. Das? See, nothing is disclosed from the FIR or whatever they say. Punch is just seizure.
Panchnama is the
What is the Panchnama? Then they will file complaint. And till moment it is complaint, they will bring witnesses for evidence before search. Suppose this man is having no involvement, they will put behind him. And for years, these officers will not appear before this court for initial deposition. And he will be inside. And section 37 will, rigor of section 37 will come. Apparently in the punch, nothing is there. But since they have filed a formal complaint, without looking into that, it's difficult for us to grant an interim bail or anticipatory bail. We'll have to balance. So let us have a, okay. It is submitted by the learned counsel for the NCB that, what you call it?
DRI.
DRI, that final
Complaint has been filed on 28/11/2020.
final complaint has been filed on 28/11/2023 from the perusal of punch. No, not from perusal of the Panchnama annexed as Annexure 3 discloses no specific allegation against the present petitioner. In that view of the matter, the DRI is directed to file produce a copy of the formal complaint. What you call it? Formal complaint.
Final complaint.
Final complaint before this court by the next date fix. Full stop.
On
When?
20,
Lordship, after
After vacation, give a date.
any date, Lordship.
Give a date as per your convenience.
Lordship, first, second,
part of
part of January.
3rd of January 2023. In the meantime, I have given interim order.
highly of
Highly of
And what about the next case?
this PA, my lord. Same
same.
allegation, my lord, the same Panchnama
Same Panchnama. Okay, let us see
on that.
on that. Let us see.
Apply.
Part of
Interim to all table হেৰি থাকিব হা আৰু পিছতো থাকিব list along with bench.
My lord, in this case, the PD was thought.
CD I have received. Today I could not go through it.
What is any
There is
interim?
no allegation against me, my lord. Only that,
Any interim?
my lord.
If
Interim was-
interim he wants to go through it.
Well,
Okay,
after vacation.
Mr. Das, learned additional public prosecutor submits that though he received the case diary but could not go through the same in as much as the CD is a voluminous one. Accordingly, he prays for an adjournment. Prayer is allowed. Please
4/1
this matter
4/1/20
4/1/2023
24.
20
Four.
sorry 24
Final decree on-
4/1/2024 5th of
Month.
January 2024. In the meantime, the interim order passed earlier.
39. Oh, 47 CD is not there.
Interim is there?
Yep.
Okay, when, Mr. Dutt?
12th of January.
12th January, interim
not
to
12.
continue.
Yep.
11? 11, it's interim. Second bail? Or what? We have granted one Pranjal. Isn't it?
My lord, yes.
Pranjal we have granted, but Madhurjo we have not. Isn't it?
Yes.
No. Yes, it is.
No, case there is not there.
The case they recall for is not received. Is this method when?
Same on 11.
On 11.
Paper is very.
October, same.
49.
49.
Huh?
The CD is not there.
What is this scan copy of the record PRC?
Oh, LCR.
My lord, already search sheet have been submitted, my lord,
Okay,
showing this petitioners as exponent. So record was called for.
okay.
They never, my lord, it was not known to them. They never applied for, my lord, anticipatory bail before the sessions court order on the earlier occasion.
Mm.
My lord, one of the petitioners, my lord, his father was an accused. He was arrested.
Mm.
And my lord, on getting the summons, he appeared, my lord.
Mm.
Then only they came.
What is the name of the present petitioner?
There, my lord, 5 persons are there, my lord. Motibur Rahman, Muhammad Ali, Ahmad Ali,
Mm.
Abdul Farooq,
Mm.
and Abdul Razak. Their names are there in the
Now, what to do at this stage? Search sheet is filed.
first it already.
What is the stage?
It's, I think, in the
LBW issue করেছেন LBW গাড়িতে হ্যাঁ দাদা LBW গাড়ি
So you approach the trial court.
he has to appear before the IO I mean trial court.
Trial court
no,
rejected.
reject.
So either we grant bail,
No, trial court rejected. I mean, anticipatory bail rejected.
rejected.
Anticipatory bail rejected. Now charge sheet has been filed.
No,
He has been
after search sheet they file anticipatory
Before that.
before the trial court because it's a 302. They went there and they said that
Our case is that, my lord, we never received any summons, my lord. Now, on earlier occasion,
okay, Mr. Das look into the case diary
modified.
and show us whether any serious attempt to apprehend this person was made or something is there to declare them absconder. If that is so, then it is a different. If not that, it's a 302, one side of the story. Other side of the story is that what will you gain in putting them inside? So whether the procedure for declaring them absconder is given. Go to it.
After some, like you know, help you anticipatory bail. Demand to polite. You after vacation. He is
Can it be
successfully,
matter day
he is
after tomorrow?
successfully evading arrest.
No, we can have it today itself, no problem if
Yeah.
Das has time because they are
Today
also
also,
overburdened.
it is not
Otherwise,
listed.
matter day after tomorrow by the last day.
Okay, the scan copies and the case diary has been received. Mr. Das, learned additional public prosecutor, may go through it and apprise this court whether there are materials to show that the petitioners were absconded,
Hmm.
were absconding during the
Investigate.
investigation, inasmuch as it is the stand of the petitioner that they were not even aware of such such
Yes, instituted against them.
that even they were, inasmuch as they were even not aware that a case is pending, police case was pending against them. Okay, list this matter day after tomorrow. Hmm.
50 also matter case diary is not there.
He's on it.
Okay, interim CD not received one,
On 11/1,
11/1.
After two days.
After you wait. Give a date. 9, 19,
22.
22.
All right.
Interim order পাতা লেখে।
51 case diary is there. Interim also, no?
Statement recorded. Let him go.
Well, I'm trying to find out. Just
11 they had received. It's a fitness. Vehicle was not having fitness. It's cattle. Where are the cattle now?
Gosala.
Huh?
In Gosala.
Okay, let them be in Gosala. You be in
There-
be in your residence. Dispose of.
One more period. That
Yes.
is the petitioner number 3 mistakenly edited.
Why?
Because, instead of Lordship, Sariful Islam Lordship, I have edited really the staff of Lordship, the name of the petitioner number 3 Lord.
Saiful.
Saiful.
Sariful is according to you.
Safiqul, or to be Safiqul Islam,
Hmm.
I have added him as Saiful Islam.
Learned counsel for the petitioner submits that the name of the petitioner number 1 wants to withdraw from the present petition.
3, petition number 3 Lord.
Petition number 3
3 Lord.
wants to withdraw from this present petition. Accordingly, his name stands deleted from the present. Then thereafter, Yagoji to order the material and pursuant to order the absolute. So far relating to petition number 1 and 2, make the name specific. Not relating it.
ठीक है संदीप है
Not come, that has not come. Files are not come.
हाँ काम
Submit. Yeah, FIR, your lordship will find
Is
page,
there motion?
motion
Okay,
Start-
because we are
start-
going through for the first time. Where is the affair?
page 11. 118 gram of contraband were recovered from one other person's lordship.
So we'll call for the case there.
Is already lordship it is started and started your lordship. My kindly note page 21.
What is the allegation in the affair against you?
Allegation against me that my wife along with some other persons were involved in that.
Where is that allegation? What is your name?
My name is Tiabut.
Siabuddin.
Yeah.
So what's your name?
My name appeared at a lordship will find. Page 12, last two paragraph.
अब्दुल कदीर सरुद्दीन
No, Abdul Qadir are witnesses.
which is the case
Abdul Qadir, Abdul Malik. From whom?
That is, in first paragraph, your lordship will find in the page 11
Hmm.
that Rupjan Bibi along with Zakir and
Where do you get that?
page 11,
Huh?
page 11, first paragraph, middle portion, your lordship will find 7th line from top, first paragraph, page 11. That Rupjan Bibi, Zakir Hussain, Imran Hussain, from that them contraband were recovered. And Rupjan Bibi, wife of Siab.
Wife of the Iman
Now, where is your search sheet?
Page, start from page 13.
Hmm.
My about my involvement, page 17, your lordship will find that it is shown as a
Page 17.
page 7.
You have
Down below-
sacrificed your wife. Then where is that? Page
down-
17.
Page 17, down below, your lordship will find absconding, it is full page. Last two lines.
No. What about your involvement in the search sheet?
Involvement that your lordship will on page 21. No specific allegation is there.
Hmm.
No specific allegation is there.
Conspiracy.
Only that.
Where is that?
And even your lordship will find that FSL report was not submitted along with the charge sheet, whether the contraband recovered is a narcotic drug or no. In last part of the charge sheet, your lordship, the case statutory period 60 days case nearing.
heroine নাকি? Heroine.
We'll have the case diary. Scan copies.
Other actions already appeared. Limited period given, he will appear at private office. Whatever is there, he will face that.
You wanted to go there and file an application. Or what? No protection for the time being. You have sacrificed your wife. There may not be any material. But we'll see. Therefore, we'll see what is the basis. Of course, if there is no legal basis, we cannot say that because she's your wife, you should be also put behind. That we cannot do. But we want to see this, see the material. Scan copies. Tell us the details. Scan copies of the case diary.
Special NDPS case.
Case diary in connection with. First, tell us the police case station case
Yes,
number.
yes.
Patharkandi PS case number 108 of 2020.
Uh, corresponding to
NDPS case number 27 of 2023 pending in the court of special judge.
special judge Karimganj be called for by the registry. Is this matter? No. Give a date. Give a 4 weeks, no problem on that. 3 weeks, give a date. But
Possible also
Huh?
before Bihu.
1st of February.
Before
We can call it before Bihu, but everything will be on holidays and all. Not get it. We will not get it.
last part of January 24th or 25th.
24th of February.
Public.
Huh?
22 case diary is not there. Case diary is not there. In this case, we have sent WT messages on several occasions. I do not know why it has not been received.
A child marriage. Whether he is appeared, we do not know. Petitioner is not present on the last occasion. He is not present.
Earlier also not there.
None appears for the petitioner on call. None did represent the petitioner on 29/2023 and 19/10/2023. Accordingly, the bail applications are dismissed for non.
23. If you was thought for interim FIR,
This is
23 case there is not there.
Okay, when?
The interim access.
Huh?
already released on 355. Offense. 379, he has showed some illegal detail in his residence. This the attack. We have NXT,
Where is the FIR?
FIR page 12.
Since interim order is filed, case diary is called for, can we now say that without looking? That is the difficulty. If it would have
The
been
interim
before,
order was passed in July.
when?
Mm.
These are the problems for you also. Every
Yeah,
day it will come, you
Yes,
take
again.
out the file, registry will do all these things, will pass this order. Even if one liner, they will have to correct, type it, will sign it. When?
Or due to our failure, मतलब, not my failure.
Not your failure. Case diary call for is not received.
July, from July, 5 months. मतलब,
Have you appeared?
Yes, sir.
The interim order was granted on 2/5/2023, and till then, since then, the case diary has not been produced by the IO. Today also, it is submitted that the Office of the Learned Public Prosecutor, that the Learned Additional Public Prosecutor, the case diary is not available today also. It is submitted by the petitioner that pursuant to the interim order that is 2020, he appeared before the IO and got his statement recorded. Considering the nature of allegation and the fact that the petitioner has appeared before the IO, and also the fact that the IO has failed to produce the case diary, the interim order passed earlier, that is 2020, is made obsolete. Yes.
Matter related to side marriage with the party.
Hmm.
FIR not to face
Succeeded.
started assessment. Started assessment of state to give the territory as well as for it was called for not. Can copy has been received, I think.
What is the IA?
I am not for implement of the party for
Then we'll issue notice. Are you on interim?
no, my lord, there was no interim.
POXO.
My lord, I am the Kaji man. And FIR, my lord, and this my lord, FIR, my lord, there is
Qazi is the
Qazi is the
problem.
person.
Have you verified the age?
no FIR.
Qazis are being paid money or what?
Yes, yes. No, in the FIR, my
No,
lord.
you will not grant you bail. We can grant the bail to the persons, not you. You are the main culprit of all this. Is it not your responsibility to verify that whether they have attained legal age?
They are indulging it.
You are the person. We are not granting you bail. I issue notice. Returnable after 4 weeks.
Yes.
At least you will not do for next few days at least. Returnable after 4 weeks. Petitioner to take steps by register post as well as by usual process.
Yes.
Please according. Yes,
Court
Amen.
appeared application is on interim. Page 12 is the FIR.
CD is there, Mr.
CD is not there. Yes.
Yes.
CD is
When?
WT message on 5th occasion. Five occasion.
But
Petitioner,
these are the ATM and all.
no, he is not named in the FIR. Here what happened, he is a Gaon Panchat coordinator. One FIR was lodged against him for misappropriation in that Gaon Panchat. He filed an application before this honorable court. Police visited, during that period, police visited his house. His family members are in which connection they are appearing. And the family members were informed about this case, so he has filed this case. Otherwise, he has no involvement in the present case. I have enclosed the interim order of that case where Lordship he is appearing. Page 15, your Lordship will find. In that case, for misappropriation, he was granted bail. Absolutely. There was some anomalies in the concert, and thereafter FIR was lost. I have apprehension in that. So only
Okay, we remain in interim. We'll see. When?
my lord,
January
29, sorry, 19th January.
19 January, interim.
Obliged.
Case diary.
It's just phase time.
Phase
Phase time.
Are you an interim?
Yes, sir.
Okay, be on interim. This category. Case diary when?
My lord, 22nd of January.
22nd of January. Interim to continue.
Twenty-seven of January, case diary is not there.
Case diary not.
Our
received.
status report was called for.
Okay, the status report call for has not been received.
TD and status report.
CD and case diary and status report call for by this court has not been received.
On 22nd.
22nd.
Lord,
Interim to continue. Interim is there?
is there. Obliged. This is your.
Hmm.
This is the 438 bail application. Lordship, this
CD is there?
28. No, madam, I'm sorry.
When?
22nd.
22nd, interim.
I left. 29 also, my lord, case diary is not there.
Interim to continue. When? Same date.
26. Also, my lord, case diary is not there. Oh, my lord, sorry, I have been here. Charge sheet has been submitted. Okay, I'm giving the charge sheet number.
Hmm.
Charge sheet number is 150/23.
Charge sheet number 150
150/23.
when public 23 under section
Dated 20/10/23.
2010-2023.
Under section 376/506 IPC.
Hmm.
Against the accused. So he has to appear.
Will appear, they already appeared according to the last order.
Okay.
The order may be appealed by the appear.
Okay. Interim to continue. It's a sessions tribunal or
Sessions time 376.
370.
Yeah.
But here is a difficulty, Mr. Das.
My lord.
When charge sheet is filed?
10 October, 20 October 23.
No problem. Interim order pass earlier shall continue till the matter is taken up. Charge sheet is filed. On summons, whenever you when you appear, then you file a regular.
Yes.
Till then it will come.
31 also, my lord, case diary is not there.
Customer time and interim, my lord.
Okay, when
22nd, my lord.
22nd.
Obliged.
32 also, case diary is not there.
Any interim?
Commercial quantity.
Commercial quantity.
Certificate case LCR may be not.
Charge
Certificate.
sheet.
When it was filed, it was submitted. I have annexed the.
When you have filed all that at that moment itself.
I have
But on last occasion, you have not said that.
Yes.
Court call for the case diary. How will get the case diary? Okay. Scan copies of
LCR special NDPS case number 122/21
pending before
Karimganj. Second judge Karim.
special judge NDPS Karimganj, along with the case diary of
Fire number
432/21. Nilambazar PS case number 432/21.
Sorry. Nilam Bazar, PS case number 432.
432/2020.
Give it it. 29th of January.
Obliged.
But it's your case that is not here.
Why 233 IA? What is the IA?
For example, I had copy is not.
Case diary call for his no interim. Huh? Is this matter? No interim, Mr. Das. No interim when?
There mirror
Before Bihu?
on 8.
8th of January. Yes.
But that took paper.
Why?
That come from
We'll adjourn then
Then it will come after vacation.
after vacation. On the prayer of the learned counsel for the petitioner, release this matter after vacation. On, after vacation and on. On, thus,
On 11th will be better. The hearing day will
11.
after Bihu. So 25th, 25th of January.
earlier interim order.
All the cases there are interim,
Yes.
all the cases.
All the
Sure?
Yes.
Interim order, if any, passed in this cases, then
diploma.
till then.
May it please your lordship.
Yes.
So this is the 438 application, my lord.
Uh,
My lord has already granted interim in the month of July in this instant matter.
Hmm.
Matter relates to dispute regarding my lord between landlord and tenants, my lord.
Hmm.
I had lodged 2 FIRs against my tenant.
we have granted bail to someone.
My lord, no, this matter only, my lord, lordship had granted interim bail earlier, my
Okay,
lord.
okay.
But subsequently, my lord, for the last 5 months, my lord, case diary has been called not yet come, my lord.
Receive, Mr. Das.
Today 40, I
40 of
this code, this one.
Google.
Time.
What timing? 40 minutes. Case diary.
Heart, Mr. With the learned counsel for the prisoner, also heart, Mr. Deepak Khanet. Hey, this is a landlord tenant fight. Are you having the case diary?
No.
There is a civil suit pending. Are you having the case diary?
No.
Or then will. If case diary is there, because there is an objection on it.
Yes, sir, but they have not acted.
But still case diary is
As
not.
your
You are an
lordship deems
interim.
fit, my lord, as your lordship.
When?
Well, he's on interim.
Interim.
Let it be on 22nd January.
22nd of January 20.
My lord, be another day or
Yes, give your date.
Isn't
That's
it?
why I'm asking. Give
Suppose we
your
have-
23rd or 24th, my lord.
24th of January 2024. Interim order
24th.
pass earlier shall continue.
Deeply obliged, my lord.
Yes, no, yes, there is. The way, if we are available at 2, then we'll take, otherwise not. Okay.
They will be arriving shortly. Your obliged. kindly pass over a
Why you can't appear before the IO of the NCB crime case?
appeal, Lordship, but mm, Monday I
No, you want a modification of the condition.
Lordship,
Why?
condition 3.
Why?
So he is he's from West Bengal.
Oh, that's why we have given that condition. What was the quantity? Heroin, West Bengal, be here. Difficult is to reduce.
Lordship, kindly pass over a matter. My senior is
Who is your senior?
MB, sir.
Difficult. We do not know.
Kindly hear.
After vacation. Please this matter after vacation. And give it. Ultimately, it will come to this court only. 12th of January. Oh,
That better,
that matter.
three
Any,
brothers.
uh,
One was who we claim to be juvenile, my lord.
yes,
that
any
was
report
that-
has come. Huh? Any report? Official report, no? Office note dated 8/11/2023 reflects that the that on 8/11/2023 the report on the juvenility of the accused number 3, namely Ritu Bora, as directed by this court under its order dated 16/10/2023, has not yet been received, though it was called on 8/11/2023. Registry to issue reminder and list this matter on given date immediately thereupon. It was treated as the part of. Why did it list this matter on 5th of January as part of? Yes.
Yes, my chair.
Why moment we have granted bail,
No, my lord.
such a serious offense, ignoring 37?
He has gone. The man is transferred to Delhi. Now, my lord, for going, so therefore, my lord, I am not acting from waiving of the condition. What I am praying is that instead of the IO, let it be the police station. Only that much I want, my lord. I am not acting that he will not go, my lord. Because he is in Delhi. He went to inquire at what time he should come. They told that he is posted to Delhi. Now, my lord, for
Who
him,
posted to tell you?
the IO. Because
Okay, we'll send it to the police station.
actually, only that
Okay.
much.
Uh,
That is there in
the
my
con-
petition. Also.
okay, allowed.
I am so deep.
It was a mistake which happened. I told you repeatedly that IO may be changed. After Sachin, IO there is no rule.
Because NCB, they are all India. They
No, I understand. In fact, it was a mistake on our part. We have
Yes, it's open for your lordship said police station.
police station. That was a
Absolutely.
mistake. So many orders we have signed. I think many corrections will come. Okay. Huh? Z, it should be treated as the
Nearest police station
police
of the
station.
resident.
Huh?
Police
Local
station,
police.
local.
Which?
I have given in my petition, I have given Namal, I have mentioned the name specifically. My lord will see. para number 6, my lord, you'll see. Para number 6, the last line. Page number 5.
Why your junior is not accustomed with this fact? How will they learn? It is you, blame is on you,
Absolutely. I take
isn't it?
I take it.
Don't blame him. You should have briefed him that if any question comes, you tell so the code this paragraph. Don't keep everything to yourself because next generation will have to learn.
The last line, para 6, page 5, the applicant number 1 and 2's houses are situated under such and such police station, respectively in the district of such and such, respectively in the state of West Bengal.
When is the date of trial? The
Trial-
dates are fixed.
Date is probably somewhere in the month of February, my lord. Or January trial, because they have appeared, they have gone to the NCP, they have taken leave, all conditions they are obliging after coming. It's not that after coming out there, because your lordship says not without the permission you cannot leave the jurisdiction. They have taken the permission, written permission, they have filed application. And then they went to the NCP. They came to my chamber. I said, go to the NCP office. NCP office, they entered. They said, it is in Delhi. So, sir, what to do? I said, okay, to that extent, I will make a prayer.
Okay, we'll pass an order, appropriate order. Okay.
I'm deeply okay.
Dispose of. We'll take care. Criminal offense.
My lord, this is a hard-won case. Lordship has noted on last occasion, 1512.
That we have noted on our own and in your absence.
Lordship, that,
We could have
that was-
dismissed for it for default, so take your seat.
Lord. Ah,
Yes, Mr. Pujari.
Yes, my lord, I have received the latest instructions, my lord. Lordship will kindly peruse it. My lord, now the department is moving the finance department for fixation of that.
How much time will you require? We are not keep creating any pressure upon you.
My lord, yes. Therefore, I have, my lord, indicated because last occasion, lordship has
Hmm.
made lordship's mind absolutely conspicuously clear that please tell us the timeline.
Hmm.
So I have asked them, my lord, they are taking for 3 months time.
Okay.
My lord, the reason is they are spelled out in my instructions.
Hmm.
My lord, first of all, they have in fact already moved the finance department.
Hmm.
Now the pay fixation has to be done in terms of FR22.
Hmm.
That is within the domain of the finance department. And my lord, during the writ proceedings, my lord,
Okay, no problem on this. Not 3 years, not 3 months. Even you can take some more time.
no,
We-
my lord, 3 months. And thereafter, my lord, similarly situated persons are always there, my lord.
We
Now-
understand.
yeah.
You had need a cabinet decision.
Absolutely.
Yes.
So everything has been spelled out in this
Yes,
instruction.
yes.
Lordship will kindly take cognizance.
Okay, no problem. We can grant you time, but it should be acted upon. That's all.
So there, we,
Yes,
there
yes,
is no
yes.
will
We
to
appreciate.
end
We have.
anything.
We appreciate. We appreciate. Pursuant to this court's order dated 15/12/2023, Mr. Borpujari, learned counsel, standing counsel for revenue and DM department, on instruction submits that to implement the order in question, the respondent will require at least 3 months time, in as much as the implementation of the order in question also involved a financial implication, as such decision will cover not only the petitioner,
Yes.
other similarly situated person.
Right.
And therefore, a cabinet approval shall also be required. Accordingly, on instruction, he submitted that finance department has already initiated
Right.
the proceeding. Therefore, at least 3 months time will be required. Full stop. Considering the submission, the matter stands adjourned for 4 months. adjourn and list and be listed on after 4 months.
4 months. I would love to kindly make it 3 months.
Divided 4 months. 2nd of May 2024, on which date Mr. Borpujari shall
But I will
obtain
please updated status.
updated instruction.
I'm so deeply obliged.
Give the copy.
Customer received
Achha,
it,
a
my
copy of the instruction is kept on record and marked as document.
because it has come from the highest authority in the revenue department.
Because
So-
exception of scale is there from 1984.
What I said you.
That is absolutely.
Yes.
Right calculation should be done, nothing.
Yes.
Please, Lord. My lord,
This
petitioner,
order.
petitioner is the mother of a retired employee of my lord, Nunmati refinery, my lord. So after the death of the my lord, son of the petitioner, my lord, he got a divine pensionable benefit, my lord, 12621 lakh, providing successful certificate. Now there is a scheme for pension, my lord.
Mm.
So for pension, my lord, they have been intimated that they require pension certificate, my lord. The challenge is that, my lord, communication dated 5/2/2019, my lord.
Let them file an affidavit. They have
Filed our affidavit.
filed a-
File, my lord. They are saying
What
that
is method is decision? Who will correspond number 1 to 5?
I am appearing for all the respondents.
Refinery.
Refinery. Affidavit was filed on 12th of April, man.
I prayed for time, my lord, to
Hmm.
file if counter if required, my lord. I contact with my client, my lord. Basic, my lord, in the affidavit, they have said that they have, if I produce their my lord successful certificate, they will provide, my lord. So, my lord, in case of pension, my lord, how will approach the my lord for successful certificate? Because until and unless there's a fixed amount, the successful certificate will not provide. In case of pension also, I don't think the successful certificate is required. I'm ready to pay if authority permit, but how do my lord, without the knowing the amount, what I'm entitled, what's the figure, exact figure, then how will
That
approach
is
my
a problem.
But the issue is that the
Because at least there must be, you intimate them that this is,
no, my lord,
oh, do not know.
my lord, issue is another issue is there, my lord. The deceased employee had a wife and 3 sons. They were the nominees as per our declaration.
Okay.
So without there being a succession certificate or we cannot release in favor of the mother.
Do you dispute that she is not
No,
their
we do not.
They are
So
not,
if you are not disputing, under the service extent service regulation, is a mother entitled for pension
It is under a scheme, my lord.
scheme, whether mother is
It
entitled?
does not say anything. It says the dependent employee.
mother is dependent.
Dependent.
Mother is, so if we take the principle of Hindu law class category class
Class
1,
one here.
class 1 and Hindu maintenance and adoption act or so class 1 category, then she is really entitled proportionately. It's a deceased estate property.
But,
So if that be so, then where is the problem or of giving the widow a portion of the
not
pension?
the widow, my lord, the mother.
Mother, a portion of the, because nominee is a nominee,
Nominee is a
nominee is a nominee.
Is a nominee.
It's a agent,
He is the agent who will receive.
it's a trustee.
It is the hands who will receive and
It's
disburse.
a trustee of the deceased. Now, if trustee are also the dependents or beneficiaries, legal heirs,
Madam-
they will definitely
Madam,
enter.
let the matter come up for admission, my lord. I'll go through it thoroughly. Because if the scheme bars, my lord, then it will be difficult.
If it's scheme
Scheme
bars,
bars, then
that
it
is
will
what I'm saying. If scheme specifically there is a bar in the scheme, then of
Yes.
course that is a different issue. If there is no bar, then what analogy will draw? Because it's ultimately the mother. And what is the status of a mother so far relating to her personal
Class one
law?
and-
That's all.
Let it come up for admission, man.
Yes, when?
You might have first week or maybe second week before
Okay.
view, mark view.
Mr. Sarania submits that as the issue involves as there is no dispute as regards the status of the petitioner, therefore status of the petitioner as mother of the deceased employee, therefore only issue remains to be decided whether under the scheme, pension scheme of the employer, of the pension scheme formulated by the employer of the deceased employee, that is the son of the petitioner, entitles her for
Pension
family
living.
pension or a portion thereof. And therefore, he will not file any affidavit. Full stop. Accordingly, please this matter on
10th?
Huh?
10th
10th of January
Earlier.
2024.
May I please, Your Lordship? What about the last occasion, Mr. P.K. Tiwari had appeared in this matter where it was,
Is this hearing or what?
it was listed in hearing, Your
Hmm.
Lordship fixed it in order so
Okay,
that it
okay.
will be disposed of.
Okay.
Because a very small issue had
Okay.
popped up regarding the parity of the charges were same, but the punishments were
That bank.
the bank part. Mr. Piketty was supposed to come, but he got stuck in Itanagar. I'll try to impress you with the. I've made a small complaint.
You impress it immediately after vacation. Okay? As Mr. P.K. Tiwari is not available today, P.K. Tiwari Senior Counsel is not available today. Matter be listed on 8th of January 2020.
Same order.
Okay, we'll decide on that. Yes, what is your stand?
Yes, Lordship, the offense is same, but the three officers stands in a different footing, Your Lordship. The allegations against the petitioner is much more, Your Lordship.
Mm.
There are all total 16 allegations,
Mm.
out of which 13 were proved, Your Lordship.
Mm.
And the other two officers, their allegations are 4 to 5, Your Lordship.
Okay. Yes, Mr. Mannan.
Yes, Your Lordship, in this matter, there were the author of this honorable court. There were three
Who are
specific
respondent
directives.
number 1?
There were specific directives. Yes, some part has been applied with. I'll provide a copy of.
Pension. Who will
Pension part has not been.
not been done?
Only thing, Your Lordship, there was the order of three parts.
Mm.
Number one is, Your Lordship, with regard to Your Lordship, find the order at page 8, the operative part at page 15. Three parts, page 15.
Mm.
The first was with regard to subsistence allowance. That was paid.
Mm.
Subsistence allowance was paid immediately thereafter. Second part was with the disciplinary authority was given the liberty
Mm.
to bring the departmental
Within 2
proceedings
months.
within 2 months. That should have been completed by the month of July, but they have completed in after we filed the contempt petition. They've
Mm.
completed in September. They've completed. A small punishment has been given. That 24,000 you have to pay with interest of 80% from your pension and other. Now the third part. with regard
That you
to
have challenged in separate petition.
No, that we have not.
You have not agreed.
Because they otherwise he has retired long. The 24
But 18% on
This
24,000, 18% is a huge amount.
thing is, Your Lordship, this 24,000, what has happened? He wanted to pay it back at that time. They
Mm.
did not. Now, after his retirement, after many years, 5,
So
6
have you
years,
challenged that 18%?
no, that we have.
That you should.
He, is,
Okay.
he has no money to pay now at the moment because he has not paid any pension, nothing.
Now where is it?
Now, the third part, with regard to the pension and other things to be within 2, that has not.
Yes.
Now, not a single penny.
Lordship, I'm appearing on behalf of Mr. Eswara. He's on late. So he has prayed for 3 weeks time to file application.
No, tell us. We'll give time for this. He is the employer. Have you sent the proposal? Who will send the proposal for pension? To the AG.
The
Respondent number 1.
will do it. Employer.
Respondent number?
Respondent, here, Your Lordship, in the contempt petition,
Hmm.
it should be the, I think the 3, respondent number, most probably 3 or 1, I am not sure. 1 is the commissioner and 3 is the deputy commissioner.
No, Commissioner 1.
1 with,
Okay. Fine. Now we want to know you file these are not questions of filing affidavit. We want to know whether pension proposal has been sent You'll have to send or you'll have to give it. It will, now it's a municipal corporation. No need for any
No, because
account.
they have their
Own fund.
They have a own fund. Your lordship, there is a rider also.
Hmm.
They have to pay 12%
Hmm.
interest to me.
Hmm.
After-
Beyond, after
beyond
2 months. Yes, you have the instruction. After some time, let Mr. S. Bora come.
Let it be at 2 because the other matter is also.
At 2.
I have given the instruction.
Huh.
May I please, your lordship, in the past occasion, lordship, the order of this honorable court is lordship page number 63. Earlier, the writ petition I put before this honorable court, and this honorable court, by order dated 19/5/2023, lordship dispose of the writ petition with a direction. Operative person is lordship page number 66.
Is a contempt or repetition?
Petition, your lordship, where in this petition we have received the paragraph like a finance. No,
Okay.
lordship, this month he is going to retire. Because of this reason, lordship, this writ petition was disposed of. And lordship, this second writ petition was disposed of, and the second day,
Where is the earlier order?
lordship, your lordship will find 120 page, 120, page number 120. That's page. This honorable court has also directed lordship to comply the direction passed by the honorable court in the first writ petition. Lordship. Detailed order was passed. In that case,
Now, what is the status on that?
lordship, page number.
What is your instruction, Mr. Bora?
Lordship, as per the instructions, lordship, he was not eligible to promote.
Mr. Sharma. You can go home. We will not hear them. We will immediately fix on reopening. Huh? You need not wait. You are not keeping well. We will not do it today. Immediately on reopening, give a date. Court, on the reopening, Musumi. That matrimonial matter. Tell us.
5th, my lord.
5th. Mr. Sharma is waiting. That's why instead of keeping him waiting.
His junior is there.
Let your junior be there. Yes.
Your lordship, the selection committee was formed as per the instruction.
Hmm.
The selection committee was formed on 23/8/2023 as per the Honorable Guwahati High Court order dated so and so, passed in WPC number so and so, for considering the case of Sri Kushal Hazarika, the petitioner. However, on 5/7/2023, in reply to the Director of Accounts and Treasuries queries, a letter was given to Sri Kushal Hazarika, the petitioner, regarding the status of the LDA post, which was already filled up by government by State Level Recruitment Commission, Assam, dated 21/5/2023. As per gradation list published from this office in the year 2014, the qualification of Sri Kushal Hazarika was HSLC, and the authority did not receive any objection from Sri Kushal Hazarika for updation of his educational qualification in the published gradation list. After receiving the provisional certificate of BA in 2014, it was updated in the gradation list for the year 2017. Hence, the Hazarika was not eligible for promotion in the year 2008. So he was not
I
eligible.
was higher secondary pass at the time of entry into service.
That is, but instructions
I
say
do
that
not
he
know
was only
this-
HSLC pass.
Everything has been examined by this honorable court, and this honorable court, by order dated 19/5/2023, directed to consider the case of the petitioner for promotion against the single vacant post. And immediately thereafter, on 22/5/2023, violating the order of this honorable court, they have appointed
Now what to do? When will you return?
lordship 31st.
I'll file it just in this coming days. The lordship may list it immediately after. the
Lordship, other
Otherwise, suppose we decide today also.
Lordship.
To decide today. Suppose we deliver the judgment today itself. Now,
Dear Lordship,
they will can-
in my retirement benefit, that may be allowed. Lordship.
no, see, even if we allow, we'll give you a notional promotion with effect from that. There are some judgments.
Yes.
Isn't it?
Yes.
After retirement, if we help you to be entitled, we'll give you a notional promotion so that you can your for the calculation of your pension.
Today, item number 61 only that is written notion.
But Lordship, there is a violation, prima facie violation on the part of the
No, no.
respondent authority, sir. Since there is
Within
a,
the
direct-
active-
Mr.
the-
Sharma,
yes, sir.
Tela, we have full sympathy upon you. We may get hold them of for committing contempt. Though you have not filed even the contempt, we can take suo motu contempt.
Yes.
But in a contempt, they can be put into jail. Sometimes it so happens you could have filed a contempt petition.
Yes, sir.
You have not filed. Now today is 28. 20. Today is 28. Court will be on vac. Only 2 days courts are there.
Yes.
You want a judgment today. They want to file an affidavit, and they are okay. Suppose we forget about it. We take this stand as an affidavit. We'll have to deliver it, and we'll have to ignore their stand. We'll have to have the record. Is not it? If it is possible, then we are proceeding. All prayers should be reasonable. It's not that we are shying away from doing cases. We know you have urgency, but is it possible? Tell us. You put yourself in the judge's chair. Possible? Tell us
Only
that
2
part.
days, 2 days in my.
Suppose we pass this order on 22nd, they do not comply with it. You are retiring on 31st, again a contempt.
Only
Better we give a proper appreciation of the facts. If you are really entitled, we'll give you all the notional benefit.
only Lordship thing is that since there was a direction on 19/5/2023, but the respondent authority has not in fact complied the order of this honorable court, and violating the order of this honorable court, they have appointed one private respondent. Thereafter, Lordship, I have approached before this honorable court. Honorable court has again directed to consider my case. And Lordship, if national benefit will be considered, Lordship, that benefit will be considered from which state, Lordship, this benefit will be considered. That is one of the, Lordship, another aspect. which is
So that,
added by-
that is suppose we decide it today. Then also you'll have to consider, or you want that if give me promotion for 3 days, I am happy. Okay, let us give you that. Okay, proceed.
Lordship, one more aspect.
Will not give you notional because we cannot determine all.
3 days promotion, Lordship. Thereafter, I will get the promotion.
Lordship, there is one more aspect. My learned friend, he has not stated anything about the speaking order. He has not challenged the speaking. I'll be annexing it my affidavit. That is also because if that speaking order was
No,
not
he is
from-
not.
have
He is not agreeable to
Affidavit.
affidavit. So let us
on the record basis of record.
see that.
Lordship, then past week of
See-
at least my settlement, my pension will be released with promotion and benefit. Past week of the
Let it be on 11th, your Lordship. I'll file the affidavit.
Learned with a P. Bora, learned concept for the respondent immediately receive instruction and may be granted a week's time to file affidavit. Prayer is allowed. Please this matter on
11th. In the meantime, he
10th.
may file a rejoinder also.
10th of January 2024. The records pertaining to the promotion of the petition be kept ready on it. Accountant. Why accountant general is a party in that case? Okay, SK may be.
May I please?
PTC name shown? Not shown.
We are trying to connect them. Then they told me that they are in out. That's why we are not.
No name of S. Bora is shown in the cause list. You wait till 2. At 2, we have called Mr. S. Bora for some other cases. We'll. Order.
Sir, the affidavit they have not filed, madam. I will. Right. Similar case, another case pending, madam.
Who is appearing for the respondent?
School department of school
Who need to file affidavit?
SCR.
Who is representing SCRT?
Yes.
Any standing counsel?
Yes, sir.
He go.
Who?
He go.
P. Coco. P. Chaudhary will be here.
P. Chaudhary?
Yes.
SCRT.
SCA.
Okay. Is he here in the court today? S. Bora. We have fixed some matters for S. Bora at 2. Come at 2.
Well,
Yes, Mr. Das.
But may kindly see one order of that page 109.
109.
The relevant portion, it starts from 111.
111. This relates to other writ petition. Some other writ petition.
Look at the item number 20. Same
Okay,
person.
same.
Only because of the court number 5 has indicated that here is a recent Supreme Court decision that promotional matters cannot be filed by a association. So we have taken a remedial measure by taking this filing the second.
So second writ petition is basically the corrective measures by the individual persons, not by the
Individual
association.
persons,
So item number 20, we can close it.
Yeah.
Close it, recording the fact that in that view, therefore. Now what order can we pass today?
Lordship, and this order was passed in 2000 in December 20.
Who is appearing? Who is appearing?
Even in December 22, this court has indicated that few persons are retiring. So now, Lordship, 2023 December. Lordship.
Now who is for the respondents? Fisheries.
On the
Call
last,
her.
on the last occasion, your Lordship has recorded they will file it by Friday, but they have not.
Okay, then we'll have their director or anybody before us. Okay, let two.
Okay.
Wait, please.
Yes.
My lord, we have preferred this IA. IA number 2834. Seeking clarification, my lord, because the learned JMFC Dibrugarh in a DB matter has granted
Yes.
a certain monetary relief.
Your item is 60.
At this date, on 25.
Who will represent the Union of India?
X or In this case,
SS Roy, SS Roy.
SS
Yes, tell us.
the pet- left
Petitioner was enrolled on when?
25 11
25/11/1991
91.
enrolled.
That you will
This is
lordship may
WPC 777975.
this lordship will get at
Page-
page 25.
Okay,
That is the part of the
just a minute. 25.
20
Age at that is 23 is one discharge certificate.
lordship. This is in continuation of lordship.
Okay,
First portion, the name, his address, other stuff, 24.
Mm.
Then 25. Date of enlistment, 25 11.
okay.
Date of discharge, 31/3/2001. After. Then
So
total-
therefore it will be 9 years, 4 months, 6
Plus-
days.
This is their record.
Hmm.
Discharge certificate. But later on, lordship
Hmm.
is pension on the basis of the discharge.
Hmm.
That is nine.
Now,
Since he was denied, he approached this court in the year 2002. Honorable Court directed the respondent to stop the and they passed
where is the denial, order of denial?
Annexure 5
Page,
in the meantime he was paid gratuity and
page 51. Na?
that is dated October 4th day of
J.K. Duggal, that is page 51.
Yes.
Huh?
Yes.
Any type copy of this?
yes,
No.
but it is there
Page 49.
49.
Okay.
since some words are not legible, so there is some gap.
Okay. This is the order impugn.
Yes.
Where is the medical determination? Anything on record?
In our affidavit there.
Yes, where is that?
It was in our affidavit, Lordship. Page 21, Lordship.
Okay.
21.
Page 21 of your affidavit.
Lordship.
By Colonel Shiva Kumar.
Lordship.
What is the continuous page?
His medical examination, Lordship.
Medical examination. There is no internal page in your affidavit. Page
21A.
21.
Yes.
Just okay. Okay, 21.
This is the release discharge medical examination report.
Okay.
In page 23, the summary of opinion.
Page 20.
The summary and opinion.
Okay. Now, what are the rules governing the field?
Lordship. It also have another order that is at page 52 and 6.
Is
This type. There it is another period of 8 years. It and Annexure 5, they said 8 years, 40 days.
but actually it is 9 years and something.
9 years and
Not
some.
here.
9 years.
Years.
That let us not go to that. detail.
Lord.
There may be calculation mistake.
Now the rule is as per rule 49 to 6 years rule
10 years
Yes.
qualifying
10,
time.
10 years. But
CCS rules.
during pendency of this case, there is some amendment
Hmm.
on 4th January 2019. Amendment of
Well, it will
Just a minute. What it says to roll 49 to read it
This is 49 is lottery for qualifying 10 years old.
for pension.
And other is
30,
3A of Central Civil Service extraordinary rules for disablement of the employee is not to be attributable or to be aggravated by the service.
So 40, do you propose that 49 to B is applicable in case of a disability pension,
Invalid pension.
invalid pension?
Lottery. It is rule 3A.
No, 49 to B is the normal pension.
Normal
General
10 years,
pension.
10 years.
This is an exception.
Exception.
This exception is under which rule? So therefore, 49 may not be applicable in case of a disability pension. This is a prima facie view of this code. Okay. So therefore, it comes the disability pension. Disability pension is under which provision? That is 3A of CCS EOP rules.
Yes.
Extraordinary pension.
Extraordinary pension.
What it says?
Disablement shall be accepted as due to the government service provided that it is certified that is due to wound, injury or disease which one is attributable to the government service or existed before or arose during government service and has been and remain aggravated thereby. Next, this is
okay. So this is the provision 3A.
and here clarification is also given. Okay. It will be seen in the new revised form C and D and E that this form of medical certificate have been so designed that they would indicate whether the entitlement criteria laid down in the new rule 3A have been satisfied or not, and therefore normally no other separate certificate in that behalf may be necessary. It is essential for the administrative officer as well as the audit office PO concerned to satisfy themselves that the death or disability is in fact attributable or aggravated by the government service, which alone makes the EOP award admissible, and for that purpose it is essential for both of these authorities to satisfy themselves in that behalf and certify that nexus and causal connection between disablement and government service or between death and government service, as the case may be, as in any particular case as laid down in the new rule 3A on the basis of the medical and the other documents regarding the case.
Just give me a minute.
Look.
This rule is called Where do you get a copy of this extraordinary?
Lordship, in the book is
That book is here with us. Yes. This will do. Just a minute. Sir.
in my affidavit, the relevant portion of the page is given. In my affidavit, page 32.
One is Central Civil Services Pension Rule. Is
Lord.
that it?
Lordship. And next one is TCS Extraordinary Pension Rules.
Just a minute. So we are having the Central Civil Services Pension Rules 1972. Okay. Hmm. Okay. Another. Okay, 3A.
In both the orders, they have to forty-
49.
Now,
2B.
how you say the argument of Ms. Bora on the last occasion was that 3A envisages two situations. One is attributable to the government. And according to her, since or is used, existed before or arose during the government service and has been and remains aggravated thereby. So meaning thereby, then disability pension will be applicable to everybody irrespective of attribution. Isn't it?
Yeah.
Now, when it's a question of attribution, then in terms of the settled law, it is the onus is upon the employer. Employer will to establish that it is not attributable because there will be a presumption that it is attributed on certain because that there are certain conditions.
Look.
Conditions are that at the time into entry into the service, you are fit and fine. It has been acquired during the tenure of service.
Sure.
Okay, even if we do not go in this case, admittedly in both the cases, if we go by the medical record, specific questions were asked prior to that, and they have said we did not have this.
Yes.
In fact, in MS Bora's case, it is specific that it was acquired during the service. Now the mental condition of these armed forces persons, more particularly in MS Bora's case, where he is feeling longingness for go home and all, and they have already served almost more. What sees in your case, 9 years.
9.
In her case, 8 years. In her case, also 9 years.
9 years.
A person has given you service for 9 years. Now, law is this. So, we'll interpret a pension law which is beneficial to the pensioner, not to the other.
No, otherwise, Lordship, I have gotten judgment that army rule is applicable to Assam.
Army rule is applicable to Assam Rifle.
Lordship, I have
If
gotten
army rule is applicable to Assam Rifle,
Lord.
then both of them are entitled.
Lord. Because the judgment I found out this court also.
Hmm.
Court Lordship in
And law is
2010.
well settled,
Lord.
that this attribution aspect is well settled.
Lord.
In
Judgment
my
Lordship.
case, my lord, after 3 years. After 3
In your case, she is having a better case than this person.
No.
Because in your case, it is specific that he was having no problem at all.
Prior to it.
And you have believed that there was a declaration. And you said it is attributable. Why attributable? Not attributable. Why not attributable? Nothing is there. So law is settled that its attribution is presumed when it is not acquired prior to the entering
Employment.
into the
Employment.
employment. Now, in this case, admittedly, if we go by the medical record, it was not. It was subsequently. After he went home, came back, and in her case, in her case, it is a kind of a little bit serious, and he was put to downgraded medical condition.
Medical condition.
But in your case, even doctor appointed, it's very minimal.
as per advice of the doctors, my lord, not to put in military duty.
No, we are not putting him in military duty. We are asking him to give him pension for 9 years of service. Or you do not want to give it to
during
him.
that period.
Huh?
During that suffering period.
But during that suffering,
My lord,
we are asking them to disability pension.
yes, my lord. But it is non-attributable to the government.
That you have also argued last occasion also. We put you some questions, you could not reply. What is the
My
law?
lord,
What is the law? Tell us.
my lord,
On last occasion also, we have wasted time. You tell us what is the law? What do you mean by attribution?
if the petitioner agrees,
Hmm.
he has to there is option, my lord,
What is the option?
to submit representation within. And here, my lord, the commandant,
Hmm.
when satisfied with the doctor's
Hmm.
opinion
Hmm.
with regard to medical report,
Hmm.
and he convened and constituted a medical board,
Hmm.
and medical board decided.
Hmm.
And after decision of that, he may be discharged or not.
Hmm.
It depends upon the opinion of that.
No, we have no problem on discharging.
And
We have
if
no
he-
problem on this. We are not interfering with the discharge. Tell us then beyond that. So that part is gone. We are not interfering with the discharge.
my lord, then he has no option, my lord,
Hmm.
to make any representation
You have
before.
already decided what is the meaning of filing a representation.
And thereafter, my lord, the Director General will constitute another medical board.
There is no dispute on the findings of the medical board. No dispute. We do not want any medical board is required. There is no dispute on the findings of the medical board. Now,
Because of that, my lord, this is specified in at page 59, my lord.
what is that? Tell us. Specify that.
Disablement shall be accepted
Hmm.
as due to government service, provided that it is certified that it is due to own injury, disease, which is attributable to government service.
We are coming to the ground zero now.
He is suffering. His case is not attributable to the as per finding of the.
So we are saying that finding is perverse in view of the settled proposition of law. Therefore, we are asking what is the settled proposition of law regarding determining the attribution, point of attribution. On yesterday or day before yesterday, it was that I asked you, you could not answer. What is the law? Tell us. What do you mean by attribution and how it is to be determined?
My lord, doctors and both they will decide my.
They cannot decide. Therefore, I am asking, what is the law?
Because he is suffering in some disease,
Suffering what?
in some suffering from some disease.
He is also suffering from some disease. Now, whether it is attributable or not attributable, what is the parameters to decide?
Parameters is that the degree of the extent of effect.
That is the decision of the parameter to determine the attributable the nature of attribute. Will record that submission of CGs. Will record that. And what
My
what
Let the medical board decide and medical board repair proceedings is their mind.
we have seen that. We have seen that. According to us, there is no basis to take a call or to held that this is attributable, because law is well settled. What are the parameters to give that opinion? Therefore, it is called a perverse decision. And we are asking you, what are those parameters? So that you can argue that these parameters are not applicable in the case. What are the parameters?
Here is the 40%.
Hmm?
40%.
Hmm.
60% is 40%.
You have understood nothing. Why are you representing in CGSE? You do not know, you have to recommend something. Yes. Hearing concluded, judgment reserved. Mr. Roy, can you give the judgments? That 2000,
37
just a minute, just a 2000
30
Hmm.
7
7 SCC 316. Tharambis. That will, you have given a copy? I have somehow kept all these judgments because on last occasion I had to do all the homeworks for
Today I have given one more 2010 1 year.
GLT 737.
Yes,
Okay. And I want, can you give me a Xerox copy of this rule? No, you may need. Okay. Okay, okay, we are having it. Give it. Wait for so many years, wait for 15 more days.
If I ordered it to take 7:30,
In both the cases, record is clear. We will go by the record. Different.
May it please your lord.
Yes, Mr. Paul, just a minute, give me a minute.
My lord, normally adjournments are not short for my inability to appear before the.
Normally adjournments are not granted in all matters, but it has been granted. So let us
Because-
end that matter there.
But that's why I have come. For the last few days, I'm not keeping well. But even then, since your lordship has expressed that I should be present, I have kept.
No, if you are not in a position to argue the matter extensively, we can take up the IA.
We'll finish it off. Because that was the understanding when the first I was disposed of also. For some reason or others, these matters did not face the
Okay,
final.
let us finish up today. Whether
Yes.
we can pass the delivered judgment or not,
Yes.
we do not know. But let us finish it.
May it-
Everybody is ready. You are ready with the records? Yes.
May it please your lordship.
Yes.
My lord, sometimes life can be very hard, especially when it is guided by misinformation. And this is one classic case of a joyful family which was torn apart on the allegation of the wife. My lord, the petitioner had been serving under Oil India Limited from 30/10/1987
Okay.
as a medical officer in the oil hospital at Piliada. And he, during
Just a minute. Okay. Yes.
he joined Oil India Limited on 30/10/1987 as a medical officer in the oil hospital at Piliada, which is under the Oil India Limited. And in course of time, my lord, he rose to the position of chief medical officer. Radio. And my lord, from 1987 till 2015, for 26 years, he had an unblemished service career. He was going to be the chief medical officer of that hospital. So naturally, some of his juniors will have some oblique motive to see that if we can remove this person from the race, then that position will be open to us. My misfortune started, my lord, when I came to Guwahati, and on the basis of some instigation by some of my colleagues, my wife lost an FIR under section 498A at Duliajan police station. I was arrested, detained in custody for more than 48 hours. And at that point of time, good sense prevailed upon my wife, and the 498A case was ultimately withdrawn. But since I was placed up for more than 48 hours in detention, by invoking Rule 20.2 of the Rule 20 of the Oil Executives Conduct, my friend has an extra copy for a rule. Kindly get what. Take a photo. No. Rule 20.2 of Rule 20. It says, my lord, Rule 20 relates to suspension. An employee who is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 40 hours, shall be deemed to have been suspended with effect from the date of detention by an order of the appointing authority, and shall remain under suspension until further order. So the suspension order has to be passed by the appointing authority. My lord, your lordship will look at the suspension order in the WPC number 3605.
Page 22.
Page 22. Now, if your lordship looks at the suspension order, your lordship will find that it is signed by the resident chief executive, who obviously is not the appointing authority of this petition. Then your lordship will look at that point number 3 in that suspension order. It says, it is further ordered that so long this order remains in force, your headquarters shall be Duliajan, and you shall not leave the headquarters without obtaining prior permission of the undersigned. So I was asked to be at the headquarters, although I am placed in suspension, without prior permission of the undersigned. During this order of suspension remains in force, you shall remain subsistence allowance as per Rule 21.1 of Oil Executives Conduct, Discipline and Appeals Rule 1982. Subject to your giving an undertaking in the enclosed format every month to the effect that you have not been employed in any profession, business or vocation for salary, profit, and remuneration.
So when this order was in, suspension order was invoked, I had my salary account was a joint account with my wife. So as soon as the money is deposited, you will have the prior knowledge that the money is deposited in the account. And the moment it is deposited, the entire money is siphoned off. Then I came before this honorable court to see, I'm a person who is under suspension. If my entire money is taken away, my subsistence allowance, why subsistence allowance is given to a person? So that he can subsist in his day-to-day life. Then this honorable court directed the Oil India Limited not to deposit that money in that joint account. I'll come to that IA later, but your lot will kindly keep that in mind because the subsistence allowance was withdrawn by the wife entire amount. So I came before this honorable court. There is an order of this honorable court. I will come to that later. Now, during my suspension period, my lord, the next communication your lordship will see at page 23.
Withdrawn. 160 was taken.
No, one page 23. The order of the order of my representation to the to the oil authority for withdrawal of the suspension order.
So on the basis of your wife's statement regarding under section 1.
Yeah, yes, my lord. Your lordship will kindly see. Tulika Gogoi lost the FIR. Pursuant to the said FIR, I was arrested, granted bail. Then subsequently by the above mentioned order dated 27/6 bearing number so and so, I was placed under suspension. Then I brought to the attention that I beg to state that my wife, Srimati Tulika Gogoi, in a statement recorded under section 164 CIPC on 24/6/2013 by the London magistrate, has stated that she is willing to live happily with me, and as such it appears that she is no longer interested in pursuing the case. In fact, the case has not proceeded any further after recording a statement on 24/6/2013 and my release on bail. Then under the circumstances, there is no reason or purpose for continuing my suspension. Moreover, continued suspension causes stigma or pain. Data begs to state there is no public interest to be served. So I brought it to the notice of the authority. At this moment, again, I pause for a moment. My lord, what has happened? Duliajan is a very small industrial town in Upper Assam like Namrup and Tikoi. The moment I was arrested in Guwahati, all the local channels published my photographs in the news channel, along with the lady with whom I was allegedly having an affair. It was flat. So naturally, this person who had a unblemished career of 26 years of service, just because he was having some coffee in a restaurant or he was meeting a friend, my colleagues in the Oil India Limited poisoned her mind, and as a result, whatever reputation I have cultivated in Duliajan for the last 26 years was gone in a flash. Now your lordship will see what. Then since my suspension order was invoked, so he consulted us that will challenge the suspension order. Then we asked him to come to Guwahati. Then this leave application, your lordship will find, the original is at page 26.
Refused.
Refuse means your lordship will see their language. That there is no provision for granting leave under suspension. Nothing. He is making a claim to go and meet his lawyers in Guwahati. The notes given, I will come to that. What was it? The type copy is at page 25, my lord. Because why I'm drawing my lordship's attention to this letter? Your lordship is aware that all absenteeism is not unauthorized leave. If you can show that we have a justified reason for leaving the station, then your lordship, at appropriate circumstances, may condone those absences.
What is your charge against you?
That's why your lordship will go from one by one, because that's how
Just want to know what is your charge?
Basically, their mind was prejudiced by the fact that I was having an affair with this lady in Guwahati. So they have used a word which normally your lot will not find being used in department. That this is a nefarious activity. And because of my affair with this lady, the whole industrial atmosphere in Duliajan is getting vitiated and all. And since my lord, my wife is a teacher in Central School of the industrial town. So she has her students, the fathers, parents, means everyone, my lord.
So SARS relates to that activities with a lady not relating to any
No,
of the.
then subsequently they
There are
copied
multiple
into unauthorized.
Please, Mr.
Ah,
Sharma, we are asking. We'll
Subsequently,
get a clarification.
yes.
We please, we'll
We'll-
say, I'll request everybody, let the other side present. We'll come back. We'll give a just this is I came to my mind.
yes, my lord, your lord will look at the beside charges at page 17. Engaged in some nefarious activities. Nefarious, my lord, in departmental process, my lord, is normally used, your lord will find probably in those EPSC cases where someone writes the answer script for someone by some other people. Those type of activities are can be termed as nefarious activity. Where is the you have to give an you have before asking for an explanation, you term it as a nefarious activity just because I have an affair, allegedly an affair with a.
What is the statement of allegation?
Yes, just page 27.
Page 27.
Yeah, but it's not that page, if I'm not proper. No, sorry.
No, it's
No, but just
it will be
just a
after
moment,
79.
just page 38. Sorry.
Thirty-eight.
Yes. Well, suspicion is very deep. A small suspicion started, led to the culmination of my termination in service profession. And this person I find was very emotional. When he find that he was arrested, his pictures, everyone flashed in the media, people in Duliajan started talking. Well, he even asked for transfer to shift him from Duliajan. Because they had other units in Guwahati, Jodhpur and all, but the management did not agree.
Yes.
Now your lordship will again I go because I have to go because since it is now your lordship will find that at page 26 I was preparing. I applied for leave to go for legal consultation with my lawyer, and they said that during suspension there is no provision for granting leave, so you cannot go because they know that if I go to Guwahati, I will challenge my suspension order. Now your lordship will find the first show cause notice in relating to my misconduct is at page 27. This is dated August 17, 2013. This has reference to letter number so-and-so, dated so-and-so, which is under an exercise of so-and-so, so-and-so, placed you under suspension with effect from 21/6/2013. The undersigned by para 3.0 of the aforementioned letter ordered that during the period of suspension, your headquarters shall be Duliajan, and you shall not leave the headquarters without obtaining prior written permission of the undersigned. However, it has been reported that on 6/8/2013, you have left the station without obtaining prior written permission of the undersigned, and despite of communicating to you by head medical services to report back immediately, you are yet to report back at the station till date. Your above action is tantamount to unauthorized absence from your appointed place of work and appointed place of work. Now your lordship will take note. Unauthorized absence. Unauthorized absent from your appointed place of work. I'll come, my lord. What is unauthorized? From your appointed place of work and willful insubordination of a reasonable order of your superior. Thus, you have acted in a manner which is unbecoming of a public servant and thereby contravene the provisions of Oil Executives Conduct, Discipline and Appeals Rules 1980. Wait. I'll come. My senior wants to say that there was a verbal instruction to me to go. To want to go and meet your lawyers, go. I'll show the turnaround. Now your lordship will say, you are hereby advised to submit your written explanation showing any cause as to why disciplinary proceedings should not be initiated against you for the aforesaid acts. Your explanation should reach the undersigned on or before 31/8/2013, failing which it will be presumed that you do not have any explanation to offer in your defense and company will take further action. So basically, they want to say that since I have gone to Guwahati, my application is dated 5/8/2013, and August 17 they say that it is unauthorized absence and willful insubordination, which is unbecoming of a public servant, and thereby I have contravened the provisions of the Oil Executive Conduct, Discipline and Appeals Rules 1982. This words your lordship will find again in that rule, because they have quoted from that rule itself. Misconduct Rule 5.
Rule 5.
Rule 5, misconduct. Then your lordship will find at 5.6.
Rule 5.
Yes, Rule 5, misconduct.
In
Misconduct.
just a minute. Rule 5. Rules of misconduct.
Yes, misconduct. Without prejudice to the generality of the term misconduct, the following acts of commission and commission shall be treated as misconduct: willful insubordination or disobedience, whether or not in combination with others, of any lawful and reasonable order of its superior. But if your lordship looks at it, that misconduct in the service rule, I am apprehending, but if your lordship looks at 5.23, the note,
Okay, 5.23.
23, they must probably have thought that even these nefarious activities can be applicable under 5.23. But your lordship is aware that these instances of misconduct are illustrated.
5.23 I'm not getting. 5.2, 5.3 direct.
There is one note at 5.23 in my.
What it says?
It says, my lord, the above instances of misconduct are illustrative in nature and are not exhaustive. But subsequently, Supreme Court has clarified in a judgment that you cannot have this type of broad parameters and bring everything into your misconduct. I'll come to that judgment later. Then
What happened to
Then-
that? What happened to that 498A?
ended there, matter.
Huh?
That's the tragedy, man. Actually, my lord, what has happened for small?
Still pending.
I don't think so. It has nobody.
Anyway, just it is.
I got bail. Then actually, what has happened after that? When I got bail, when my photographs, videos, everyone was circulating in Duliajan and all. That place I did not want to stay. I asked for them that you transfer me to Guwahati or Jodhpur, where I can go with my family. But she was working in Central School Duliajan. She did not want to leave.
Okay, 5.28. Notice 5.28.
Willful subordination is 5.6.
No. Willful subordination is 5.5. Acting in a manner prejudicial to interest of the 5.5, even remotely delegation.
And
Then 5.6, willful insubordination.
or
Then
disobedience.
5.7, absence without leave or overstaying the sanctions leave for more than 4 hours.
My book is my 5.1.
5.18, absence from employee's appointed place of work without permission or sufficient cost. I think this will be the 5.18. So accordingly, they have included it is under
This works.
misconduct.
Yes.
Okay.
I'll come,
I
madam.
think that is your case.
What I'll come, what is
Typical.
misconduct?
was dropped. Finally, to drop the inquiry. For the other charges,
What are the other charges?
the other regarding those 5.6 and
So basis is the
5.5.
arrest, basis is the arrest and having a nefarious activity. That is,
There were the other charges were there.
Huh?
So the other charges of subordination and his not performing his
so
job.
basic is that two part. One is that his arrest is a nefarious activity, forget about that. Then other part is his insubordination, because in spite of you barred him, don't go, he has gone out
And
of this.
there were other charges also.
What are the other charges?
The charge sheet was taken also at the time. Ultimately,
So
all
you
the
have
charges-
issued a show cause without the other charges.
ultimately, not-
Then he filed a reply. Then you file a search sheet. That's why I want straight to go to the charges.
And then inquiry took it, and this particular charge of 5.18
Hmm.
was dropped.
Hmm.
Drop in the sense that
He was found guilty in against which charges?
you not come to case 101.
Yes. Why should we lengthen all these things in this case of kind of cases? 10?
101, the final order, the last offer court.
No, I want to see the charge, actual, which are the
Page
findings?
79.
730.
79 or 38 is the charge memo. 79 or broad pieces.
Page 41.
Statement of imputation we
Page
want.
41.
Page 41.
Page 41.
Your lordship
So
will,
nefarious activities first.
and your lordship will see the language.
Third paragraph.
So
That the
lordship, the
undersigned
second
took serious note.
Uh-huh.
I'll read from second paragraph.
Just a minute, just a minute.
lordship will see the second paragraph.
Huh.
That it was reported by the then head medical service and head hospital administrator that Deepak Kumar Gogoi was neglecting his official duties and engaged in some nefarious activities. This in total discussion
What is the
of
neglect? How
And-
he has neglect? Where is the statement of allegation?
and are not constituted the point. Then thereafter the other charges are also there.
Tell us, show us the charge.
Yes, yes, sir. That the undersigned took serious note of the contents above where he mentioned that it was really a matter of concern for the department as well as for the organization as a whole. Radiology is one of the most important types of hospital. And such doctor is not at all determined. Such kind of behavior may even affect his diagnostic capability as beneath the faculty. Then the third is that under the above circumstances and while considering the undersigned above mentioned letter by to assign different responsibilities. Then comes the criminal aspect.
These nefarious activities have no connection with my discharge of duties in the hospital.
Mr. Sharma, you are a seasoned counsel. Tell me, assist us. Can a statement have allegation stating that it is a nefarious activity? What is that nefarious activity?
The inquiry report otherwise than
No. You will have to give a chance to a person that you are charged with this. What is the necessity of statement of allegation? Charge is one thing, statement of allegation is something different. Why statement of allegation is? Statement of allegation is the explanation of the charges. That on these facts you have committed misconduct or fraud or whatsoever.
correct.
Where is there?
And this is their opinion.
Where is that? That on such and such that you have neglected, on such and such that you were not there. On the basis of this statement of allegation, what will you prove?
He participated in the inquiry.
Yes.
And the inquiry report therefore throws some light into these activities. So if I can just read the inquiry report, see that
How can without basis inquiry conclude it?
the inquiry in the he has given his reply pursuant to this. So he knew what these activities are. So therefore he gave a reply. Based on the reply, he participated in the inquiry process.
Okay, where is his reply? See how he knew. What is his reply? Say, let us
Page
see.
28. First reply to the so-called.
No. Because your statement of allegations, there is no whisper against all this radiology department. Your
These are
statement of
opinion.
allegation is only nefarious activity. Now he replies, you are not satisfied. That your reply is not happy, so charge memo. Sar's memo statement of allegation is not related to the show cause except one part. And now,
It- it-
and statement of allegation do not disclose any fact which he can defend. Matter ends there.
And my lord, what has happened? Right? During the pendency of this writ petition also, when my wife came, I did not oppose.
Oh, we are not concerned with your wife.
Yes, yes.
His anxiety is that
Hmm.
because of this case, he is not getting the benefit. If we, whatever way we decide, he will have his own option. We are not passing any order in
Yes,
his
yes,
favor
because
if we
the-
decide it. If we are not deciding it, of course, he will have a right. That is a different aspect altogether. He is having no say.
My lord, this matter in 2015, unless some people did not have an oblique motive to throw me out of that line, this would have ended in 2013. Because when 498 matter was compromised, both the husband and wife, they were willing to live together and forget that incident of 498A and filing of that FIR and showing my image in
Yes,
TV.
but they have taken specifics then. That without making specifying nefarious activities, how can I reply? Why should it take so much of time in this bill? 2015 it's pending. Yes, where is Bora? Bora, this is a case. We requested the BTC. Initially, it was Saliha regarding a compassionate appointment. Who will place the matter before then what is happened? So, Saliha said that it is the BTC authority.
Yes, sir, there is
So, we'll adjourn it. You give a copy to him in terms of the earlier order date 1512. And Bora's name will be shown. Already there is a direction.
well, let's point the cause list and name this one.
That we have already directed. Again, we will direct. And you give a copy and of this order, download it or give it to you. Okay. As per naam to dekho na. As per naam to dekha. No, done. In spite of this court's order dated 15/12/2023, name of Mr. S. Bora, Learned Standing Counsel for BTC is not shown. Court of Registry will ensure that on the next date fixed, name of Mr. S. Bora is shown in the cost list. Please this matter in the second week of January 2023. In the meantime, a copy of the writ petition be furnished to Mr.
Right.
This matter will, your matter will take some time. So after we are in the midst of a hearing. So we'll go to you after the completion of the order, if time permits. No way out because we are in the midst of a hearing. Okay. You be there.
My lord, this matter is entrusted to B. Chaudhary, my lord. And it again after some time because I have no knowledge about it.
After some time on day after tomorrow.
Day after tomorrow.
Okay. Mr. S. Bora, Learned Counsel for the respondent SCRT, prays that he may be granted. Matter may be adjourned and be listed on 22nd. Prayer is allowed. List accordingly.
In item number 19,
Hmm.
I have the affidavit. We are filing the affidavit. Kindly, kindly take it up after the reopening. Madam. On the reopening, I'm filing the affidavit. I have the. It is already ready in the process.
So in this month, 3 more persons are going.
That extension, you file it.
We are filing it, madam, today.
Today they are filing it. So we'll immediately reopening, we'll take it up.
On 4th,
On 4th may not be possible. We have fixed too many methods. Possible on 4th? Okay, Mr. Nath, D. Nath Lanet Senior Government Advocate submits that the affidavit on behalf of the respondent
Yes.
is being filed during the course of
Yes.
the day. In view of such submission, matter sets adjourned and be listed on 4th of January 2023, 2024.
Total of this was that all, everything has been complied with except the pension.
Hmm.
Pension part, my lord, process is on to release the pension.
But
Because
that is, that
there
will,
is a act, my lord, our DNC
that is,
act, as per this act pension, and it depends upon the grant of from the government.
okay.
Yeah, yes, that
So what is the procedure? Tell us. You will have to place this demand before the government.
already some other persons also not, but their demand is there, my lord, and that has not been received, madam. That process is
And how you expect within what period you want to that it should be?
some time, my lord. Let it be posted after 2 months, my lord. In the meantime, hopefully that everything comes.
But that is in this case. In other cases, there is no clock running. Here, interest at the rate of 12%. Isn't it? No, already there.
It is there.
It is already there in the order that if you do not pay within this period, so it should get a preference to save public money. Otherwise, we may impose that the concerned officer.
What will post it to the 2 months, my lord. In the meantime, hopefully that comes from the government.
Okay. That's good.
I have.
Yes, Mr. Bora, Mr. S. Bora, Learned Counsel, appearing for respondents.
No, only one, my lord.
Respondent number 1 submits that the proposal for payment of pension has already been initiated as the fund will come from the state. It will take some time. Accordingly, he prays that matter may be adjourned for two weeks, 2 months, within which it is expected that the order in question shall be complied with and the petitioner will be paid the pension as directed. In view of such submission, matter stands adjourned and be listed on
Sometime in February.
26th of February 2024. Mr. Bora shall apprise this court on that day regarding the status of compliance of the order. Yes, Mr. Bora. We'll have to send invitation to you.
Sorry, I was
No, not only in this case, yesterday also. Yes, what is your instruction?
yesterday I was been informed.
There are some cases yesterday, day before. Yes. What is your instruction?
Preliminary report will be taken. The report.
Who is Deputy Commissioner? Give the report. This is not done. This is not a roving and fishing inquiry.
Are you
whatsoever, you expedite it. You expedite it. This is not the way to deal with this kind of situation. Subject to what you say, our consideration whether certificate was issued genuinely. If it is issued, if it is issued. If it is certificate is not fake and competent authority has issued the certificate, where is the question of this robbing and fishing inquiry? And in the meantime, a year of a student has gone. Mr. Bora, ask your clients to be sensitive. Dealing with a young children. When? Day after tomorrow. Give a copy to him.
I have to see it.
Huh?
He has got.
You are having it. We have not expressed any opinion as such, but this should not be like. Mr. R.M. Das, Learned Counsel for the petitioner. Oh, sorry. Learned Counsel for the what you call it?
Social Justice and Empowerment.
Department of Social Justice and Empowerment has submitted that an inquiry report has been submitted. Preliminary inquiry report has been submitted by the Inspector of Police CID Assam on 19/12/2023. As the said inquiry is a preliminary inquiry and certain clarifications has been sought from the Deputy Commissioner Dibrugarh, District Commissioner Dibrugarh, in absence of such information, a complete report could not be filed. Mr. D. Bora, appearing for, is a Deputy Commissioner Party? Mr. D. Bora, Learned Counsel, appearing for the respondent number 5, submits that he will obtain instruction and apprise the Deputy Commissioner to answer the queries at the earliest. And accordingly, he prays that matter may be listed day after tomorrow, that is on 22nd, so that he can get an up-to-date status regarding the up-to-date status. Accordingly, prayer stands adjourned. From the report, it is seen that, from the preliminary report, it is seen that, what is this queries? Please, yes.
Our name may be.
We will not reflect with you. We have recorded your name, that's all. Yes, Mr. Bora. See, if you have issued the certificate, you cannot take a different stand that no, he is not having that. If you take that, then you have played a fraud, or whosoever was there. If you can have such robbing and fishing inquiry, we will also have it. But what are you carrying? Yes.
But
what is your fundamental arguments?
Well, so far, this misconduct of unauthorized absence is concerned, I have an explanation. All absence cannot be termed as unauthorized if you have got an. Number one, this all allegations of nefarious activities, it can't be sustained. And if I take your lordships to the inquiry report and the charge, coming to that, your lordship will find in the inquiry report they have discussed charges which are not framed against me. How do I respond to them?
Sure.
Yes, but it will go a little bit slow, but I'm not in the best of. I'll go.
No,
slow.
see,
Right.
fundamental, what is your fundamental argument? That whatever in the show cause is not in the statement of so cause that you have replied, that is not in the statement of allegation. Now, whatever is in the statement of allegation, the allegation, statement of allegation should an explanation, and that explanation is not there. What is that nefarious activity? That is one part.
And before even framing of the charge, they have indicated their opinion.
Okay, we'll come to even that later on because they have given you a chance. They have given you a chance. Even they might have that biasness will go on a later stage. Now, charge is framed.
The first chokers, then the reply.
Then the reply. Then they give you the charge memo and statement of allegation.
Then my reply.
Then your reply.
Then the inquiry.
Then the inquiry report. Now, now one of the fundamental issue regarding this charge is insubordination. That is a fundamental thing they have raised. According to them, these are the rule and this comes within the definition. Therefore, in the given facts of your explanation, whether that can be taken to be an unauthorized absent.
And the unauthorized absent, as your lordship has pointed, that you have not even indicated the period of that unauthorized absence, simply by using an
Now, what
expression.
about the charges we want to see regarding your discharge of duty that radiology department? We want to see that.
Yeah. First, I'll not take much time. First, since I have already reached the SOCOS, your lordship will see the SOCOS reply. Then we'll come to the charge memo that my reply. Now your lordship has seen at page 27 last, prior to your lordship rising up. Then your lordship will see my SOCOS reply, my explanation at page 28 and Anchor 5. When misfortune falls, it falls heavily. This person was returning from Duliajan to Guwahati.
That your Ford Fusion or something got accident.
Yes.
Ford Fiesta.
Ford Fiesta. Then it was in such a bad condition. You used to tow it to somewhere else. Then you was a Montel shock. You have come. Okay.
And I escaped it.
Yes, somehow you have escaped.
So
you are here. That's why Mr. J. Pator is client agent. That is a fortune for not only. Yes. Page 28.
28 and 29.
Reply.
Then,
Mr. Bora, I do not think you will have any role today. You can have the nap.
I'm enjoying my.
If you are enjoying, you enjoy, no problem on that. But I do not think. We'll give him a patient hearing. Then.
I think it can be concluded my part is very.
Your part is, we are clear. We are absolutely with you. If there is a valid decree or award in your favor, you can get it. Only your difficulty is that by virtue of a stay or status quo, you are not getting a fruit of a decree. We say in a civil law, it's a fruit of a decree. You are nowhere related to this case. Okay. So suppose we allow this writ petition.
And then also
allow this writ petition. Whatever you will get, you will get, and you will get your own. We will not pass any separate order in your favor. Suppose we dismiss this.
No, that is also subject. My petition is.
No, your clarification is that whatever the way, we will decide whether his dismissal is correct or incorrect. Suppose we say his dismissal was correct, upholding, this petition stands dismissed. Interim order stands earlier, stands vacated. Okay.
So it will not get vacated, it will merge with the final.
Yes, merge with the final order, or even if we can say that any interim order is stands vacated.
I'll address you.
Okay, if this writ petition is allowed, it's allowed.
That's why, my lord, I want here.
It's
No complications can
it's
be.
allowed. Suppose yes, suppose what we subject to what Mr. Kumar says, it is not his case in this petition. Even if we allow that money should not be given to you. This is not your case. No.
That embargo only has to be lifted.
That embargo is by virtue of an interim order. Matter the moment this matter ends, that embargo ends.
That part only little bit of part. So I just want to
No,
hear Mr.
Okay, you
I want to hear. So I just
My
want
friend is presuming that my petition will be dismissed and he will enjoy the fruits.
No. I'm very clear. I'm just learning from my friend. I just want to hear some of the adjective he's using so that I can rebut that.
No,
adjective.
that's why we want that you should have a cup of
Coffee.
black tea or coffee there,
He did
so
not
that
have
this dispute does not arise regarding the words.
No.
Use of words. Let us forget about this use of words.
That the misfortunate, he said that the misfortunate falls. Who
No, we are,
on whom, my lord?
who is fortunate, who is not fortunate is not at all our business.
That's
We
why
will see.
I just want to get there.
We will
should not
see
be-
the legality whether the
I'm
Oil India
not
has
being bothered
proceeded in terms of rule, and whether in the given facts he could have been implicated this
different thing.
punishment. That's all. Nothing. Who is fortunate, who is unfortunate, we are not none of our business.
Because of the fact that the oil is holding my
You want
money,
to set rhetoric. You want to enjoying the rhetoric.
whatever they have hospital for.
He did not have lunch. Also. I enjoyed my life. Even I am not well.
He generally skips the lunch. Anyway, proceed.
He's making his mood. So
Yes.
page 30 is my leave application, my lord.
Page 30.
Yes. With effect from 6/8.
But we'll not deliver the judgment today, huh? Because if possible, we'll hear the other matter, another case we have fixed today.
Or your lord can make it part of that, carry it after the case.
We'll see. We'll let us complete. Go.
I will continue for some time, but I don't think, well, I don't know, I'm feeling a little bit uneasy. But let me continue till I.
No, you continue. Otherwise, it will be futile exercise of this.
So we can take your lord, you can take it up immediately on court. I don't have it.
Okay.
Court of
Yes,
January.
let us proceed first.
Yes,
Let
ma'am.
us
Yes.
with an idea that we'll finish it up today.
Yes.
Let us proceed with an idea that we'll finish it up.
Yes. Then Annexure 6 at page 30 is my leave application from the period from 6/8/2013 to 6/9/2013. Then on 5/9/2013, I file another application for extension of my leave.
Yes, 32.
Yes. Then 34. Page 34 is that since I have served in that organization for 27 years, I even submitted a letter on 25/9/2013 because at that time, my lord, all that has gone viral in Duliajan. At page 34, I can ask my model employer that please let me join back services in any other location besides Duliajan, namely Guwahati, Kolkata, Jodhpur. This will not be a problem as I'm designated as OSD at the time of my suspension. And I have also, because the management had a grievance that my show cause notice was not received, then I have given those particulars at page 2.0. Then your lordship will see the reply of the oil in regard to my show cause notice. At page 37, dated 23/9/2013. Page 37, your lordship got it? In this regard, please be informed that your reply is not found to be acceptable. With regard to statement made in paragraph 1 of your reply under reference, we would like to reiterate that despite of head of medical services informing you that he is not the authority to sanction your station leave permission, and only on the undersigned can grant such permission, you had left the station without obtaining prior written permission of the undersigned, which was specifically mentioned in the suspension order dated 27/6/2013. It has been reported that you are yet to report back at this station. Your above actions tantamount to misconduct under Oil Executives Conduct and Discipline and Appeals Rule 1982. View above, you are hereby advised to report to Head Medical Services, Portrait. Then, my lord, the charge comes now at page 10, Annexure 10, page 38.
Just a minute. Who is this residential chief executive?
He is the disciplinary authority, my lord. Page 38, November 16, 2013. The undersigned proposed to hold an inquiry against Dr. Deepak Gogoi's salary code number so-and-so under Rule 25 of Oil Executives Conduct, Discipline and Appeals Rule 1982 amended. The substance of the imputation of misconduct in respect of which an inquiry is proposed to be held is set out in the enclosed statement of articles of charge, Annexure 1. The statement of imputation of misconduct in support of each article of charge is enclosed as Annexure 2. A list of documents by which and a list of witnesses by whom the article of charge are proposed to be submitted, substantiated, are also enclosed as provided under Rule 25.3 of the said rule. Dr. Deepak Kumar Gogoi's salary code under suspension is directed to submit a written statement of his defense to raise the undersigned on or before 27/11/2013 and to clearly state whether he admits or denies any of or all the articles of charge. Dr. Deepak Kumar Gogoi's salary code 1614 under suspension is informed that an inquiry will be held only in respect of those articles of charge as are not admitted by him. He should therefore specifically admit or deny each article of charge. He is further informed that if no such written statement of his defense is presented on or before the date specified hereabove, an inquiry will be held by the inquiring authority, which shall be nominated under Rule 25.2 of the said rules. Dr. Deepak Kumar Gogoi's salary code 1615 under suspension is also informed that if he does not appear in so and so. Now you'll also see the statement of articles of charge framed against Dr. Deepak Gogoi at page 39. You'll also be looking at page 39. Page 39 is the statement.
Just a minute.
Annexure 1. Everything started with that arrest. And that too also, my lord. While posted and functioning as OSD in Medical Department Oil Duliazan under salary code so-and-so is alleged to have committed the following acts of omissions and commissions constituting serious misconduct. He failed to maintain absolute integrity, devotion to duty, and acted in a manner unbecoming of a public servant. It was reported that Dr. Deepak Gogoi was neglecting his official duties and engaged in some nefarious activity, which is in total disregard of the
any specific date of unauthorized absence?
Well, your loss will come below. Well, let me go. Well,
okay.
Now you'll also see it was reported that Dr. Deepak Kumar Gogoi was neglecting his official duties and engaged in some nefarious activity, which in total disregard of the company's image and are not conducive to the position of a senior doctor. You'll also will keep this in mind. It was reported that Dr. Deepak Kumar Gogoi's salary code was arrested by Duliazan police on 21/6/2013 in connection with case number so-and-so and taken into custody for more than 48 hours. That view above, as per clause 20.2 of Rule 20 of Oil Executives Conduct, Discipline and Appeals Rule 1992, Dr. Gogoi was placed under suspension with effect from 21/6/2015, wherein it was ordered that so long the suspension order remains in force, his headquarters shall be Duliazan and he shall not leave the headquarters without obtaining prior permission of the undersigned. That it was reported that on 6/8/2013, Dr. Gogoi left the station without obtaining prior written permission of the undersigned, and despite of communicating to him by the head medical services to report back immediately, he is yet to report back at the station till date. That keeping in view his continuous absence from field headquarters without permission in spite of his advice of his superior not to do so, a so-called notice was issued to Dr. Gogoi on 17/8/2013. By which he was advised to submit his written explanation, showing cause as to why disciplinary proceedings should not be initiated against him for the aforesaid act. It was also mentioned that his explanation should raise the undersigned on or before 31/8/2000, telling which it will be presumed deficient. That in response to the above mentioned show cause notice, Dr. Gogoi has sent his reply by letter dated 38/2013. With regard to his reply, the undersigned acceptable and advised him to report to medical services quoted. However, he has not reported to head medical services till date. Thus, by the above action of omission of Commissioner, Dr. Gogoi failed to maintain absolute integrity, devotion to duty, and acted in a manner which is unbecoming of a public servant. So these are the general allegations and the rules are quoted. Now, the statement of imputation is at page 41. Same, my love, first two paragraphs, nefarious activities. That means as if I am engaged in some organized crime syndicate to term my activities as nefarious activities. That the undersigned took, I'll read third paragraph, that the undersigned took serious note of the contents of the above mentioned letter, and the same was sent to the head medical services by letter number so and so, where he mentioned that it is really a matter of concern for the department as well as for organization as a whole. Radiology is one of the most important diagnostic medical sections.
Just a minute. Yes, proceed.
Wherein it mentioned that it is really a matter of concern for the department as well as for the organization as a whole. Radiology is one of the most important diagnostic medical sections in a medical institute, and such behavior of a senior doctor dealing with radiology in particular is not at all desirable. And such kind of behavior may even affect his diagnostic capabilities that may lead to fatal situation. And I was posted at that time as a OSD also. Not I was supposed to work as a radiologist during my suspension period, my lord. That under the above circumstances and while considering the larger interest of Oil Hospital, the undersigned by the above mentioned letter suggested head medical services to assign different responsibility to Dr. Deepak Kumar Gogoi. Accordingly, Dr. Gogoi was assigned different responsibility and re-designated as officer of special duty with effect from 10/6/2013.
When were you suspended?
My lord, page 27/6/2013 order.
So 20,
with effect from 21/6.
so you were arrested on
Arrested
21.
huh?
21/6.
21/6.
The FIR was of 20th of June 2013.
Arrested on?
Arrested on 21 of June 2013. And bail was granted on 24/6/2013.
No, 21/16 is arrest.
Arrest. Bail was granted on
No,
24/6.
forget about it. Suspension is on
21/6.
same date.
Same day.
27 June is the order date.
But with effect from 21/6.
Okay, 27 June. Okay.
But with effect from 21/6.
Now, 10th of June 2013, how it's related to that nefarious activity?
Hello, your lordship.
One aspect, nefarious activity deals with a misconduct under 5.17 under this rule. 5.17 was decided by the inquiry officer to be not proved. So therefore, we are not going on that basis. We are completely on the aspect of unauthorized absence.
Unauthorized absence.
And
therefore, if unauthorized absence, so therefore these are gone.
These are gone, but
so for unauthorized absence, you have dismissed him from service.
Yes, because major penalty can be imposed.
Oh yes, imposed. No doubt about that. No doubt about that.
Though he is taking it on that aspect of nefarious activities, finally the inquiry officer found that it cannot be proved. So it was not proved. It was dropped.
How you reconcile with your charge?
No, this charge is always there. Unauthorized absence charge.
Unauthorized
is
absence.
always
No,
there.
we are not on unauthorized absence.
Yes.
Can we brush aside all this while dealing with a departmental proceeding?
These grounds, these charges,
Inquiry officer has said not proved.
Not proved.
But dealing with the as a whole dismissal from of a person from service, can we ignore this? When you say that for his activities, what we do not know what activities, such behavior, that behavior, what is such behavior, that behavior may be unauthorized absence. That behavior mean nefarious activities. Nefarious activities is not at all disclosed. Even if we assume that this such behavior of senior doctor leading with radiology relates to unauthorized absence. Even if we assume unauthorized absence cannot be there because you have already posted him as official on 10/6/2013. On 10/6/2013, there was no nefarious activity. Nefarious activity started on 21/6.
Lordship may not link neighbors activities with unauthorized
Okay,
absence.
now
It is an
okay,
independent charge altogether.
even on 10/6/2013,
Yes.
there is no question of unauthorized absence.
It is not there.
Then
Unauthorized-
how you reconcile? Why will not determine that this was that you have a bias and predetermined mind?
Unauthorized absence started on 6/8/2013. On 5/8, he gave a letter seeking
Understand.
on
It all
6/8.
started after 21/6. After 21/6, all started. Arrest.
Yes.
He's coming to Guwahati, meeting with accident, whatsoever,
Yes,
everything after 21/6.
Yes.
You say that for his conduct, it may disturb our radiology department.
It's a wrong choice of words, basically.
No, not wrong choice of words. Therefore, he was already put as an official on 10/6/2003.
10/6.
How you reconcile it? That itself shows your bias.
That is true. But the so-called the charges have to be dealt with independently.
No, Sergeant will deal with independently. No doubt about this. But we cannot brush aside your conduct. This is one
Yeah.
of the important facet of a judicial review dealing with a departmental proceeding. It's the most, we cannot sit as an appellate authority.
But if a particular
We cannot have a satisfaction that he has done this or not done this, or that this conduct is this or that. We'll go by the settled proposition of law, what is unauthorized absence and what is willful unauthorized absence, and under what circumstances you can impose a punishment. Law is clear on that thing.
that particular transfer is based on a complaint, page 52, wherein certain officers of his particular department.
Where is that charge?
So that is not a
So
charge.
that is, forget about that.
That is what I'm saying.
So therefore,
not-
if that is there, if therefore that would not have come anyway, we'll deal with
Independently,
it. We'll
the
deal
charge
with
of
it.
unauthorized absence would have warranted.
Just
his
I
dismissal.
wanted to
That
know,
is-
I thought that this may be a date mistake. Why this has come?
They have written all these things. That is true. And there are some wrong choice of word also. Nefarious activities, they did not want to disclose what the nefarious activities is. I asked them, why not come out clearly in your,
Says that this you have done it.
they are docile, these people are docile. They said, cannot write all these things.
No, but they will have to prove it, nah?
So, but then that charge was dropped. This is
Okay,
my case.
forget about it. So anyway,
Independently, unauthorized absence was
okay,
warranted
proceed,
dismissal.
Mr. Mahajan, Mr. Proceed.
Then page
I
41.
do not think this is a method to be so lengthily argued.
Yes, but problem is that if I don't point your lordship to the chart, because in the
No, of course, yes.
then your lordship has to correlate the charge with the inquiry report.
Yes. So this is
Because
this is
I
a third.
say,
Then?
ultimately, ultimately your lordship say, let us presume, your lordship may allow my thing. So what is the remedy that I can expect from? In the meantime, I have already superannuated.
You will get the if you are reinstated, then you will get the benefit if you can satisfy that you are entitled.
That is, but they will come with a plea that no work, no pay. But I'll counter that.
We have passed yesterday a judgment that no work, no pay will not be applicable when it is for your fault he has been dismissed and is out of.
And here also your lordship will say,
And he proved that he was not gainfully employed during this meeting. There's a judgment.
And the judgment is that he is gainfully employed, is onus is upon the employer.
Just check.
As clear as that. We have passed the judgment yesterday. The open court dictated.
so that is, and if I'm, say, if I'm not conclude, if I'm get more money, my wife and children will get more money. During the pendency of this writ petition also, on 2019, the matter was sent to MITI.
No, I have seen that. These will not go into all this.
I voluntarily, even today, I am also saying.
No, that part will not at all enter.
Yes.
Will not enter. That is up to them. that is up to you, how you deal with, what remedy, legal remedy you take, it is a absolutely different issue. We'll decide on the merit of this case.
Yeah.
There was an interim order on your plea that if it is given, if it so happens, so there is status quo order or whatsoever, they come and they say, see, for this order, we are being deprived. So that is a different issue. If we decide this matter interim, what happened in interim is nothing. Yes, proceed.
Now, page 41, the last one. That further it was reported that Dr. Deepak Kumar OSD was arrested by Duliajan, so and so. This are your lordship can happen. That the head medical service via letter number dated so and so had informed the undersigned regarding above incident. The undersigned via letter dated 25/6/2000 sought approval of the competent authority to place Dr. Deepak Gogoi under that in view of as clause 20.2 of rule 20 of all executive conduct with effect from so and so, wherein it was so long the suspension order remain, his headquarters shall be Duliajan and not leave. Then, my lord, Dr. Deepak Kumar Gogoi, by letter dated 24/7/2000, appealed to the undersigned against the order of suspension, wherein requested to revoke the suspension, allow him to resume his official duty. He enclosed the bail order dated 24/6/2013 and a copy of statement of his wife, Srimati Tulukaya Gogoi, along with his plan. That Dr. Deepak Gogoi, by letter dated 5/8/2013, had requested head medical services to grant him privileged leave and station leave permission from 6/8/2013 for a period of 10 days. That the competent authority had not granted Dr. Gogoi's privileged leave and station leave. The same was informed to him by email dated 6/8/2013. That it was reported on 6/8/2013, Dr. Gogoi left the station without obtaining prior written permission of the undersigned. And despite of communicating to him by head medical service to report back immediately, he is yet to report back at the station building. That in keeping his view, his continued absence from field headquarters without prior permission in spite of advice of his superior not to do so. A so-called notice was issued to Dr. Gogoi by letter number dated 17/8/2015, by which he was advised to submit his written explanation showing cause as to why disciplinary proceedings should not be initiated against him for the aforesaid act. It was also mentioned that his explanation should reach the undersigned on or before the swing. That in response to the above mentioned so-called notice, Dr. Gogoi had sent his reply by letter dated 30/8/2013. With regard to his reply, the undersigned by letter dated 29/2013 had informed him that his reply was not found to be acceptable and advised him to report to head medical services board. However, he has not reported to head medical services till date. Meanwhile, head medical services by letter dated 1/10/2013 had enclosed one letter dated 25/9/2013 from Dr. Deepak Gogoi, wherein Dr. Gogoi has expressed his unwillingness to join back in Duliajan and requested to join back in services in any other location other than Duliajan. Thus, by the above acts and omissions and commission, Dr. Deepak Gogoi failed to maintain absolute integrity, devotion, duty, and so and so. He is acted in a matter prejudicial to the interests of the company, disobeyed a lawful and reasonable order, and also an act. Now, you also will see that the acts which were tantamount to misconduct, they have quoted those relevant provisions only. Then they say again at page 44, it is the misconduct under those rules. At page 45 is the list of documents relied upon in case during the DP, my lord. And page 46 are the list of witnesses. 3 witnesses are there. Now, you also will see my written statement of defense at page 48.
What is page 52?
Page
52, Annex 12A.
That was the complaint that led to his transfer as a OSD, which is a reference in page 41 of the so-called.
These are not relevant.
These are documents which was furnished after the so-called. After this is furnished to us after furnishing of the reply to the charges as additional document, because we have taken that plea back.
In fact, this is the first letter that we have relied upon. And list of documents, the first letter is 7/6/2013. Submission is not correct.
No, that was not given. He said, anyway, he wrote it later and the document was given.
List of documents, first
A
letter
list of documents was there. maybe the copy was not
I
given.
don't think
That is not a dispute.
Page 48, my reply may kindly be seen, my lord.
Yes, yes.
It was dated 5/12/2000. I have received
Just a minute, page.
Page 48 is my written statement of defense against the charge memorandum dated 16 November 2013.
Charge is at page 38.
Yes.
Hmm?
Yes.
Charge memo, just we have read it.
Yes, 38. Page 30. I have your lordship is reading page 48. Paragraph 2 is my reply in regard to that nefarious activities. Then in regard to my appeal against my suspension, that is at paragraph 3. And paragraph 4 is against that letter, which simply spoke that my reply was not found to be acceptable without giving any cause and reason. Paragraph 5, my lord, where I have taken the plea that page 52 and page 53 document, which your lordship has just referred, was not furnished to me. Paragraph 5. And on 10/6/2013, I have been designated as a OSD, and I have not been informed of any such reason why I had been designated as OSD. And paragraph 6 is my explanation, my lord, why I have sought a transfer from Tuliada. And paragraph 8, I have said specifically that in the memorandum dated 16/11/2013, there was no acts which involves moral turpitude. Then I requested for the copies to receive. Then, my lord, at page 51, that documents were furnished to me on January 10, 2014. And 7/6/2013, these are not even part of the charges except, so I did not reply to that. 7/6/2013, 8/6/2013. Your lordship has made a query that who is this person of residence chief executive? That he is not my appointing authority is reflected in the communication at page 60. That my appointing authority is the chairman and managing director as per the oil executive recruitment policy 2007. Resident chief executive is not my appointment. The subsequent documents are of my information of assets and all, up to page 63. They have even gone to the extent of seeing my Facebook post of dictating the atmosphere in here. Your lordship probably has read page 52. Now your lordship will see my reply at page 64 against this page 52 and all. What I can say. How they can know, my lord, all these things at paragraph 3.0 at page 52. However, it came out later that he undertook a misadventure of so and so, so and so. Because of the language, I did not feel it proper to read page 52. Well, your lot will see my reply at page 54. And page 53 also may be seen. They talk about Dulyadhan as a close society.
Closed society. Things are out in public. Everyone knows what is happening.
A person comes to Guwahati. Okay. He is involved in a nefarious activity. Okay, fine. You do not allege anything. What is the nefarious activity? In evidence, you bring that there was an IMA conference. He was supposed to attend that. Instead of attending that, he was busy with some lady. He was supposed to meet some officer. He did not meet the officer, so therefore he is negligent. Where is the charge? Where is the statement of it?
So my friend was fair enough that
Where is
we
that?
can't disclose it.
Where is that? Gone.
My entire endeavor is only on one point. Unauthorized absence would be a good enough ground for warranting dismissal. And that was a charge that was proved. That will be my only endeavor in my reply.
Better we should not waste the time on that. We'll write the judgment on the other part. Let us come to the unauthorized absence.
Yes.
Yes.
Other issues I am also not touching. No point.
Not necessary.
No point. Exactly. No point.
I have read your inquiry report. The witnesses of the evidence. Specific allegation that on such and such as the origin. Where is the charge? That it was a meeting, that this is the document, you have been delegated to the meeting. You were not present. Instead of that, you were there. Somebody is having some affair, it is none of your business.
So your lot will just give a cursory glance of my reply at page.
I have read it. Everything I have read. I am now reading page 91.
No, yes.
That is the important 8.3. My
Then
problem is that I am a little bit fast reader.
Yes, ma'am. Then when all this was going on, my lord.
Yes, Patwari.
My lord.
You should be happy. You should be happy.
Page Annexure 14 at
this case may be for happy. This case may be a result of reason for happiness for you. Yes.
Yes, lot will see
8.3. Yes.
Now during the pendency of the earlier writ petition, my lord, that is, I have enclosed that order at page 68, connector 40. When I came first challenging the suspension.
Just will go to that. Just a minute.
So this was the direction passed in that writ petition dated 5/3/2014, and the petition was disposed.
Just a minute.
Yes. Page, my lord. When I came challenging the suspension order, page 68. Page 69 are the directions, my lord. And especially the 3, because it was a joint account. So the money, when it was deposited, these oil officers who are more concerned with their close society, with inform, and the entire money is withdrawn. That's why I came before this honorable court saying that my salary, that subsistence allowance, should not be deposited in that account. Then page 71 is that they refuse to review the suspension order. That rejection order is at page 71. It is dated 19th of March 2014. They did not interfere in the or revoke the suspension. And they said that it will continue till the conclusion of the departmental inquiry. Okay. Then, my lord, when my representation was pending, then there was another writ petition, my lord, that is at page 74, WPC number 5207 of 2014, my lord, which is still pending, my lord.
What was the prayer in that writ petition?
My lord, 5207 2014 is there. The order is at page 910 2014.
5207. Page 75?
Yes. And it was probably, my lord, after my dues were stopped depositing in that account, my lord, then they came for implement.
They came for implement in this writ petition.
Not
that is
both
5207.
both.
They got implemented.
Yeah, we did not dispute.
Now, what was the prayer in the second writ petition?
My lord, this prayer in 5207 was virtually to not to deposit, credit all the dues of the petitioners payable to him by the company in his savings bank account number so maintained by is maintained by him in his Dipsy bank. Okay. I have given a separate account, then I'll come to that. The lordship will read page 75. Good. Now your lordship has seen the enquiry report at page 77. So the gist is, you have discussed everything here, but where are the charges where I would, to which I can respond, my especially at page 79, the lordship has said 3.0.
Inquiry report starts at
Enquiry report starts at pilot page 70, 76 is the covering letter.
77.
77. 77 up to
6 to 90.
94.
Yes. Now, what is your legal argument?
Yes, I'll connect. Yes, since your lordship has read the enquiry report, it has made my job. And conclusion is at page 94, probably your lordship has seen.
Yes. Huh?
Conclusion your lordship probably has seen at page 94. So against this enquiry report,
Preferred an appeal?
no, we filed a, first we have to file a representation that category, that 21 July 2014 it was. Page 95.
Yes.
Then your lordship will, I filed a departmental appeal.
No, no. Where is the order?
Order is at this, sorry, page 97.
Let us see that.
Yeah. It's virtually the cut paste of all the chronology of events which you're talking about. So the ultimate penalty of dismissal from service of the company was passed, that is at page 101. Then against that pilot, I filed an appeal, which is at page 102, dated 6/10/2014. This is an appeal under 32 of the appeal rules, pilot. And the appeal was dismissed on 23rd of January 2015 at page 110, Annexure 21. So one order already your lordship has taken, that is order dated 9/10/2014. Pass in,
5207.
pass in WPC number 5207 of 2014, not to deposit the dues of the petitioner in that SBI account of Julia Zapra. That's one. Then another is there is the order dated 25/1/2016, pass in IA number 10282 of 2015 in WPC number 3605 of 2015. IA number 10822 to kindly take over.
IA
1082 of 2015 in WPC 3605 of 2000.
IA 2896.
1082. ठीक है, sir.
What is that? Just read it.
Oil should inform the court about the exact amount due to the petitioner from oil and status quo regarding release of money to the petitioner. Your lordship got that IA? Your lordship will see the order of 25/1/2000.
25. This is IA 1082.
Yes.
25/1.
Filed by all. Filed by all.
Oh, that this is short an explanation what to do.
Yes,
This is
exactly.
also that is
There are
also
two orders now.
okay.
Your lordship will see that order at order dated
25/1/2016. There is
just a moment.
one order is 22/5/2019.
So 25/1/2016.
25/1/2016.
The first your lordship will see the order that 5207 you're already seen not to deposit in the State Bank of India to Liazan Branch. That is an WPC number 5207.
25/1/2016. Status quo as on today regarding release of money to the opposite party, writ petitioner shall be maintained. That is the order.
Yes. Then 22/5/2019. Pass in IA. Same order.
The status
1082.
quo in terms of order date 2020 shall be continued till further orders in accompanying writ petition.
Yes, because a clarification was sought by the oil. Your lordship will read the second paragraph. And it was disposed of.
Okay. Provident fund and gratuity.
Then your lordship, they came with this application for vacation of the modification of the order. That is their application of the private respondent. My wife is IA 1022 of 2018.
Still your wife, not divorced. So they file IA in WPC 3605.
1022 in the 3605.
In they file 3605. Okay, in this petition where we are carrying.
Yes, IA number 1022
Okay. Keep the IA number 1022
of 2018.
2018. IA 1022. These two IS. This is filed by Mr. Patwari's client.
Yes.
Earlier, 1022 by.
It 1022 by you.
Yes. Now your lordship will look at the order passed there on
79.
79. For filing this interlocutory application, a prayer has been made by the applicant for vacation, modification, alteration of the order dated 23/6/2015 passed by the court in WPC number 3065.
So this is disposed of.
Was issued. So I was from day one, I was consistent in my stance that earlier also you came for a stay vacation. On the same ground, you are filing this second application, and that was disposed of.
Okay.
So they are saying that it is we are
Where
not
is your second petition? Second IA?
2834 of 2022.
Here we have all the
What was the earlier?
earlier one.
Your lordship will see, kindly look at IA number 2834 of 2020.
I am an IA 2834 of 2020.
Yeah. Your lordship will see the orders they have annexed from page 19.
Now you want stay vacation in the IA in 36, IA filed in 3605. No, I'll cut short. They file a writ petition against the dismissal. Okay. No, this is one. Earlier they file a writ petition saying that please give the money in this account. Isn't it? Now, oh, court. Then, so in the second writ petition, that is, you file a stay vacating petition. The status quo was granted. Status quo continued because his money was in gratuity and so on and so forth. So status quo continued. Now, by this application, which order you want to vacate? Hmm. 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 No, status quo was part after hearing you in the earlier order.
Yes, sir.
Understand in file by them, but matter has been decided.
Yes.
They say whatever you have said, they say please tell us what to do to honor the trial court's order or to honor the high court's order. So get us a clarification. Court says okay, status quo. You are not a part. So you want to vacate it. No. Why are you? You are nowhere in this now. Yes. Tell us. Tell us. Yes, 35. The Duliajan authority will pay the.
Where was the embargo? Where was the constitution officer why not to disperse the to this account? Can it the last court is back to the account of very bad. This part is the same account number. If it is not the same account, where was the embargo? Where is the constitution officer on this? They obtain a status for themselves, then they say we.
I still submit that I'm ready to disperse the subsequent
No.
to any order.
Okay, understand.
This is not my money. I have to finally disperse.
You think it as a please help me. Whom to honor? His case is that where is the confusion? That two accounts are different. Forget about that.
Deepak Gogoi's money. Deepak Gogoi's money ultimately. So I need to disperse now. There are two orders.
Okay. These are non-issues.
Non-issues, exactly.
These are non-issues.
Exactly.
Yes.
That's
That's why this matter is not being heard because of I'm sorry to say, because of the hyperness on the starting of the matter. Everybody goes back to. Yes, proceed. No.
That's why, because I have been appearing in this case for 2014. I know the background. The application which was filed, the 1022 of 2000.
No, now we are discussing as
those prayers were same, and I said,
okay, we're not going there.
and my status quo was because
now you argue the legal point on your merit. That's all.
Now you're not.
Let us cut short. Let us not waste the judicial. What is your argument and what is the case clause you are relying upon?
Provision.
Yes, madam. What is your expectation today at 3:30? Come forward. Mr. Das is also sitting. And where is Das? You are sitting for what?
Our part is gone.
This? Or you can go home. This matter you are waiting.
Yes.
You have no role. You have no role.
Yes, I have.
You have no role. At best you have an instruction till before next date, what happened to 498A case? You have that. Okay. On the next date, you inform us.
My lord, I leave it to your lordship. I am
No,
here for
don't
this
leave it to
matter.
the judge. What you say?
Because then I will be safer. If I take it on myself or my learned friend, my lord, then it will be a controversy. It might
No, you will definitely like to accommodate her, but we are not going to stop in the midway.
Lordship will not forget this fact.
No, my lord, I was just I was just hearing this matter. My lord, the point is now very called out. We say that, oh, means what would be the magnitude? The law point is simple. What is the magnitude of
No, what about,
punishment for the
yes,
offence
what
committed?
is your status? What is your status?
Status lordship, while we have already prepared the supplementary record.
Hmm.
So supplied to the court.
What is the basis of the supplementary record? Xerox copies. How will you convict him?
Lordship, all those documents have been supplied, but only those documents only supplied to them during before trial, commencement of trial and before.
No. How will you exhibit those documents?
For secondary evidence, lordship will call.
Now you are seeking a bail also.
My lord, I am seeking a bail also.
Bail is
and
also
my lord,
bail also before us.
yes, my lord, and that quashing of that 174 which they have added, my lord.
Can we take up this matter tomorrow?
My lord, I would be
Leaving.
and tomorrow I have matters.
Okay, when then?
My lord, then it has to be after vacation because your lordship court will be or on 22nd, my lord, can I take a chance?
22nd you can take a chance. But
My
you
lord, but
know,
that chance would be very weird one, my lord. I understand.
huh?
That's the last day.
She's saying no.
No.
Reopening, fourth. Third.
Fourth, my lord.
Third.
Fourth.
Third.
Fourth, I will not be
Third.
there. My lord, the Monday then, my lord, following
Monday?
Monday.
Next following Monday. 8. Okay, we'll pass this order on 8. We'll on that decide. More or less, we have now settled the proposition. What is what?
My lord, can we come back on 2nd?
Second is a holiday here.
Holiday.
No.
Third.
Hmm?
Come on.
Just give the decided date, then we'll fix it.
8th, my lord, will
Eight,
come.
eight.
My lord, kindly fixes it at 2 p.m. My lord, we'll take
Okay,
that.
then we'll now this time we'll record it as a
Kindly,
2
kindly,
p.m.
my lord.
Yes. Okay. You have come out. You should give me
And my
that.
lord, another thing is, my lord, since this thing is going on, my lord, we have also asked for a supplementary that whatever they have submitted, we got one. I just got a hold of it. And my lord, if your lordship recollects, there was one particular date which was mentioned for saying that compliance of attachment and proclamation was done. My lord, that was something which was mentioned as this is the order date and this is the execution officer was.
So therefore, if it is
that
there,
not there.
we can properly now decide.
Order is not there.
Is these
No
are
order is there.
okay?
Order is not there, but even then the witness for
We'll see, but we'll see.
So my lord, 8th
8.
of
Eight.
January.
Yes.
So we'll meet in the new year.
Yes.
Much obliged.
Yes, Mr. Kaur. At least let us finish one thing because all are not completed, either part hurt or yes.
So, my lord, when my wife came before the court to my provident fund, gratuity and all, at that time, my lord, I pointed out to the honorable court the section 13 of the Payment of Gratuity Act.
No, we know that under what circumstances gratuity can be withdrawn. Okay.
So no gratuity payable, are you aware? No gratuity payable.
No, we'll come to that part a little bit later. You just argue on their punishment.
Yes.
That is the then other questions will follow. That will hear Mr. Bora also. What is the order and how it can be implemented?
The first citation, my lord, that I am relying is 2012, 3 SCC 178.
For the proposition?
In regard to absence from duty.
Okay.
There are 15 to 24.
Give the judge. Are you having extra copies?
I'm just checking, my lord.
Others can go, give the dates.
Hello, can look into it. I have marked it as my copy. I'll look at the item. 2000 square, yes, no,
That's the killer.
2000 square here. No. If it connects that, I think
Third in part, list on third. This time it will be over. We have somehow retrieved certain thing, we'll do it. You keep it. On that, we propose to dictate on that day itself, if possible. You give whatever you want to give. Any change in dates? Yes. 12. Okay.
Internet is slow enough.
Very slow. We need the replacement of all this system. Now it is an outdated, and this will cost us around 10-15 crores.
Only.
For him only. For him only.
For this upgradation, this Supreme Court has earmarked 4,000 crores.
No, not for whole of the not I think 50 crores or something like
For High Court, I think for Guwahati High Court, it's 100 crores.
100. No, only for no. That is different. That is for e-court phase 3, not for that. If we want to improve the network accessibility with this existing building, not with the new equipment, those other things will come. That is a different first phase. So therefore, we will have to take a decision whether for this middle period we should spend so much.
In Supreme Court, earlier there was a signal connectivity was meant. What they have done, they have given free of rent to establish some towers on top of the Supreme Court. That's why connectivity has improved. In our High Court nearby,
Our connectivity is the earlier system of some cable and all. Now it has now fiber. We'll have to change it from that to fiber, and this will involve a huge cost. Otherwise, we'll have all revamping. So therefore, why should we spend this for the internet?
Because now printing 45 pages, 50 pages, when we can view it online and we have become a friend.
We are processing all those things so that even
No, main problem is that now to look into the judgment in the place where I sit, there is no zero connectivity. I can't even view the WhatsApp.
No, that's true. That's true.
Only
if it is better here, even inside our chambers, there is no connectivity. We have our own dongle. This cable is not. Yes.
Paragraph, my lord.
This is for the proposition
of absence from unauthorized absent.
Paragraph?
From paragraph 15 also, it's the same allegation.
Paragraph 15 to?
Paragraph 15 to 24, right? 21. 20 is.
Yes, 20, 21. 23. 23. You have highlighted.
Yes, ma'am. So your lordship will just read it slowly. Your lordship will find the same rule like this. All India, every government servant at paragraph 15. Every government servant at all times maintain absolute integrity, maintain devotion, do nothing which is unbecoming of a government servant. In the case of the appellant referring to unauthorized absent, the disciplinary authority alleged that he failed to maintain devotion to the duty and his behavior was unbecoming of a government servant. The question whether unauthorized absence from duty amounts to failure of devotion to duty or behavior unbecoming of a government servant cannot be decided without deciding the question whether absence is willful or because of compelling circumstance. If the absence is the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventuality due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure of devotion to duty or behavior unbecoming of a government servant. In a departmental proceeding, if the allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful.
By the way, what is your charge period of unauthorized absence?
That also they have not clearly specified, giving a broad period from that you have absent from this and you have not joined. And I have given my explanation.
There is no specific period, no, that from this to this.
That charge they have not framed only specific.
Not specific.
So one cannot travel beyond those charges. These are all, your lordship, I need not cite any judgment on that point. One cannot traverse beyond the charges.
Yes.
Yes. Actually, last night.
In fact, this judgment, what was that case? Or day before yesterday, we read this judgment. Mr. N. relied on of a police person. He was sick. He was outside.
These are all familiar law. The only thing is that, my lord, we do not know our fate until the order is signed. That's why we, although we, your lordship is familiar, we just make it a.
No, that is necessary. Yes.
Then next is, my lord.
Next case.
Just a moment.
Mr. Sharma, we will hear you on the reopening. We'll let you publish.
But then also your lord will then also give me some time to formulate all this citation. My junior is saying that you take time. I'll formulate all this citation, prepare a brief note on the citation on the proposition
I have noted all the pages and
chronologically your events your lordship has noted, and that is sufficient for your lordship's consideration. My lord, I believe, my lord, only my friend will try to show from the inquiry report that this unauthorized
unauthorized absent because specifically willingly. And you have that record how you proceeded.
Record is already there. In fact, there is no dispute on the papers that is
No
already on
dispute.
record.
Therefore, it's not necessary.
Not record. My entire endeavor is this was a willful unauthorized absence on his part. Because he refused to join. His letter is there. He said, I cannot join in Duliajan. So that will amount to his willful absenteeism from job. One.
Another aspect you address, just coming into mind. Can there be any distinction between a person willfully not joining duty while in his duty and a person who is under suspension? He's under his presence per se or absence will not affect the hospital. Had it been a case that can be an argument from Mr.
Yes, because you have to show a correlation.
Okay, these are the
otherwise
these are the thoughts.
Suspension doesn't amount to severing of the relationship.
No, not severing. No, not at all. No question, because he still remains an employee.
Exactly.
Still remains an employee. Now, for dismissal, a doctor on duty, not joining the duty, and resultantly, the patients are suffering. This is one aspect. And a person who is under suspension, and his purpose to keep that man in the headquarters, purpose of keeping him in the headquarters, and purpose of a person who is actually on duty, keeping him in the headquarters, is there not any distinction?
The logic is emergency service. If service exigency requires, I can immediately ask him to come and join, because there is some operation that only he can do. Suppose.
Okay, that may be
that is the reason why we need to, or for any employee.
That may be an argument. That may be an argument. Just a question.
Yes, the lordship posed that question, so immediately struck my mind also.
Yeah.
So next date I'll summarize this citation. So that what they replied, then I will.
My reply will be limited to only that. I will not traverse into other aspects because I know your lordship's view regarding those other things.
Though Mr.
Your
B.D.
lordship has
or
said
learned
that- sorry.
senior counsel has extensively argued the matter, but due to paucity of time, the argument remained inconclusive. Full stop. Accordingly, matter stands adjourned and be listed on,
Not on court.
not on court. Divided.
Yeah.
First week I'm first second. My only problem now is, well, sometimes the Supreme Court gives the date 24 hours ahead. I go there, then I say that I had a matter. Then it tell your junior to inform the High Court that you have a matter in the Supreme Court. They will accommodate. We are not going there.
Not 1999.
That's the problem.
When?
9th?
9th?
Ninth.
9th of January 2020. But we'll conclude that on that
And
day.
only subject to if there's sudden emergency matter comes up.
No, sudden emergency understand. Plus, at least prepare the
Yes,
note.
yes.
Then we can your judgment and all you place it.
Otherwise, I will not seek adjournment.
Then we at least we can start his. If it goes beyond that, then it's not.
Because my lord, one matter I am taking as a PIL is of the toilet
No, that
facilities
is-
all over. That matter comes up anytime, and my lord, the court wants my presence. Although I can do it online, they said no, we'll hear you live.
Okay.
Yes, yes, yes. Yes, yes.
For all this endeavor, not part.
No. Please as part third. Can you give the judgments you have relied on?
No, but I'll summarize it and give it.
Can you give before 9?
Yes, yes, yes. yes.
So
As
that-
soon as the reopening, I'll give all
No,
the judgment.
when the matter is listed,
Yeah.
can you give it the
No, I'll give it
date,
as soon as the reopening starts, my lord.
date prior?
Yes, yes.
We want this your judgments on a note on 8.
Yes.
Shall we also submit our judgment?
If possible,
yes, we'll
you
do that
give it.
because otherwise lordship is only going to read their judgments, not ours.
No. So therefore, give
So
yours.
let's vote the judgments.
Give yours.
We'll do that. We'll
We
do
do
that.
not know whether we can. We'll have time to read it. Hearing matter generally do not go into because we may make up our mind. But
This is a matter where you will not forget because this could have been resolved at the earlier stage. But you also have seen that invisible hand not allowing the parties to reconcile. Otherwise, if he was posted in Jodhpur or Guwahati, his family, everything would have been shifted. He also, my lord, worked for 26 years.
that we will
prepared
not
for-
go to all this.
That's why
We wish all of you best. The rest we will decide on question of topic.